in the middle. Yes.
Good morning. As you can see, we're short 2 judges, and Jane Markey is our presiding judge this morning. I don't have visual on that screen over there. Can everyone see the other 2 judges? Unfortunately, they're both ill, so they're appearing by Zoom today. Judge Markey, I'll turn it over to you then.
Oh, I thought you were going to.
Oh, I'm happy to do it. I just didn't hear.
Sure.
Is that okay?
Yeah. I just texted you. I just wrote you back. You must not have gotten it.
Very good.
Go ahead.
Okay.
Thank you.
All right. So most of you have been here before. You know the rules. If it's a contested argument, 30 minutes aside, though it's rare that we need that much time. Please stay focused on the legal issues unless the facts are particularly salient to your issue. If you're unopposed, 15 minutes. If there's more than one attorney on a side, please let us know how you're going to share your time. And if you want time for rebuttal, you can let me know at the outset, and I will try to watch the time for you. And if there's any cases involving children, please do not mention minors by name. Refer to them either by initials or as the minor or the child. All right, so with that, I'll call the first case on today's docket. Docket item number 1, Andrew v. USAA Casualty Insurance, docket 356487. Oh, yes, you take it off when you're arguing. Thank you. And I appreciate everyone agreeing to wear masks today. We didn't want people too close.
Good morning. Mark Ronzato on behalf of the plaintiffs' appellants. With me at counsel table is my co-counsel, George Sinus. This is a very important case, challenging several of the 2019 changes to the Michigan No Fault Act. We brought this case as a constitutional challenge only, and there were both prospective and retrospective aspects to the allegations that we made. I am going to confine my arguments here today, unless prompted by the court, to the issues regarding the retrospective application of these changes.
Okay.
That's because the plaintiffs in this case, the individual plaintiffs in this case, were injured long before the changes took effect that we are challenging. Those changes took effect in July of 2021. And the question presented is whether these people have vested rights in the contracts that they entered into before before these changes took effect. The Our challenge, basically, that I'm going to be talking about today comes in two forms. The first is a constitutional challenge under the contract clause, Article 1, Section 10 of the Michigan Constitution. The whole purpose of that clause is to prohibit states from enacting laws that interfere with pre-existing contractual arrangements. And what we have here is, in my estimation, a classic case in which there are pre-existing contractual relationships that exist between my clients and the insurance companies who are defendants in this case. And what has happened is that in 2019, taking effect in July of 2021, there are fundamental changes to those contracts that have been visited on them because of the changes that the legislature imposed. I think it's important to focus initially in this case on the contracts themselves, because the contracts in this case are not contracts for the sale of goods. They're not contracts for employment or performance. These are contracts that were purchased by my clients, and they purchased a particular type of coverage at the time they were purchased. The price of that contract, the price that my clients had to pay for that contract, was actuarially fixed by the defendants. And what has happened in light of the changes that have taken place in 2019 is that the coverage that my clients purchased for the price set by the defendants for the particular coverage involved has in fact been changed. The defendants in this case would in fact ultimately reap a significant gain as a result, a windfall, if you will, because the policy that was purchased by my clients has been changed. The coverage has been changed, but it's what they paid for when they purchased these policies. So our first attack on this is the contract clause of the Michigan Constitution. The contract clause of the Michigan Constitution is clearly something that is governed in this court by what is a sliding scale. The Michigan Supreme Court has adopted the Supreme Court of the United States opinions on this point, and they have ruled that depending on the severity of the impairment of the contractual rights involved, the level of scrutiny that a court is to apply is to increase. And what we have here, despite what the trial court ruled in this case, is a direct, not circumstantial, not indirect, a direct effect on the contracts that my clients purchased, some of them, one of them at least, over 30 years ago. So under this sliding scale, this court's level of scrutiny differs, it seems to me, rather dramatically from that which would exist in the equal protection or due process context in the rational relationship test. As we've tried to explain in the our brief, the fact is that the scope of review, the level of review, once an impairment of the contract is found, is quite different than it would be under a rational relationship test. And the interesting thing about this case, Judge Shapiro, is, as we've cited in the brief, I think this case can be decided on the basis of AFT Michigan, an opinion that you wrote, which is cited, I think, on page 22 of the brief that I've written in the case. And that's a decision, by the way, that was affirmed by the Michigan Supreme Court. And it was a decision by the Supreme Court which reaffirms one important point, it seems to me, and that is the burden that exists in a contract clause case. The burden is on the state, in this case, the defendants, to establish that the elements of what it takes to legitimize any change of a contractual relationship. And what has to be shown, unlike the standard that would apply in a rational relationship test, is a significant legitimate public purpose, and that the means adopted for that purpose were reasonably related to that purpose. And I think fundamentally, both the United States Supreme Court cases on the subject of the contract clause and those in the Michigan Supreme Court, which have examined the Michigan version of the contract clause, have made it pretty clear that there's an intermediate level of review that this court engages in deciding these things. But the fact is that I guess I would say on the contract clause game that I would rely very much on your opinion in AFT Michigan. And I think on the basis of the analysis that you employed in that case, that these attempted changes to the contractual relationship that exists have to be found unconstitutional under the contract clause. Now, I realize that there is Ashwander and the avoidance of constitutional issues in general that this court adheres to. And there was a non-constitutional claim, which we attempted to raise in this case. We were a little bit frustrated by what the trial court did, but we attempted to raise in this case because the defendants immediately after the complaint was filed a motion to dismiss. There was obviously no discovery done. Judge Patel is not feeling well. We, in response to that motion, we cited the Michigan Supreme Court decision in LaFontaine and 2.116 I-5 and requested the opportunity to amend our complaint to assert no longer just a constitutional theory, but basically a contract theory. And it's a contract theory that was predicated largely at the time on the basis of the Supreme Court's decision in LaFontaine. And I want to just take a few minutes to talk about the LaFontaine facts, because I think there is a real parallel to this case in LaFontaine, because what happened in LaFontaine is that in 2010, Chrysler and LaFontaine, a manufacturer and a dealer, entered into a contract. The contract was subject to a Michigan statute, the Motor Vehicle Dealer Act. At the time, one of the provisions of that Motor Vehicle Dealer Act was a provision that governed how close another dealer could be to the people making this contract, LaFontaine and Chrysler. At the time in 2007 was the date of the contract between LaFontaine and Chrysler. At the time, the Motor Vehicle Dealer Act radius, how close another dealer Chrysler could place to LaFontaine, was 6 miles. The Chrysler, 3 years later, when the statute still had the same provision, that is a 6 mile radius, entered into a letter of intent with another dealer to establish a potential dealership selling the same types of vehicles as LaFontaine. So it would have been subject to, again, the Motor Vehicle Dealer Act. After this letter of intent was signed between Chrysler and this other dealer, the legislature changed the Motor Vehicle Dealer Act and it expanded the radius to 9 miles. And interestingly enough, the letter of intent had been signed with a dealer that was going to locate between 6 and 9 miles away from LaFontaine. So it was a situation, obviously, in which the old law was, in fact, would have been complied with, but the new law wouldn't. But the key thing is that the Michigan Supreme Court in that case had to decide whether this letter of intent and the contract that had been entered into in 2007 between LaFontaine and Chrysler was governed by the act that existed at the time it was entered, or whether the 2010 act applied. Now, what is most important from our perspective with respect to this case is how the Supreme Court resolved this question. And what the Supreme Court did in LaFontaine, they did not create new law. The law had existed actually for many, many years before, but there is a concept of incorporation that's reflected in the LaFontaine decision. That concept of incorporation was clearly expressed by the court, citing one of the earlier cases, actually a case that had been cited many years before. But here's the quote: "The obligation of a contract consisted in its binding force on the party who makes it. This depends upon the laws in existence at the time it was made. They are necessarily referred to in all contracts and form a part of them. Now, the ultimate decision by the Supreme Court was in favor of Chrysler, and it was based on this concept that the relationship between these two parties was predicated on the law. Because the contract had been subject to a law, the relationship between these two parties was not governed by the law that was created when the act was amended, but it was the law that existed at the time it was made. Now, to me, this is a case with significant parallels to what we're dealing with here, because we have without question a contract that is subject to a statute, in this case, the No Fault Act. No question about that. In fact, it's the provisions of the No Fault Act are incorporated into this contract. And what we have in this case is a change in the law many years later, just as there was in LaFontaine, a change in the law. But the fact is that the change in the law has no impact, because it's the contract when it was entered. When you have a statute that is incorporated into a contract, it is the statute in existence at the time the contract was created. So in this particular case, the statute that existed at the time Ms. Andary was injured in 2014, or when Mr. Kruger was injured in 1990, was the contract in existence at the time.
Could you speak to the workers' comp cases?
Yes.
That the defense, I think, relies on, in which changes were approved?
Yes, but the comp cases go both ways. There are comp cases that have said in the Supreme Court that, in fact, it's the law that exists at the time of the injury. Okay, the comp cases, though, are different in one very, very important respect. There is no contract involved.
But between employer and insurance company, right?
Well, employer and insurance company, yes, that's true. Okay, but the comp cases, some of the comp cases, some of them used to say that it's the law in effect at the time that the injury occurred. Others say something different. But what's important about LaFontaine is that there was only one exception to this rule of incorporation, that is, contracts that are subject to a statute incorporate the statute in effect at the time of the vesting, if you will, of the right. And that is what they said: unless the 2010 amendment expanding the relevant market area is retroactively applicable to existing dealer agreements. That's the only exception that the Supreme Court recognized in LaFontaine to this incorporation concept that we tried to add to this case by amending. You understand that the trial judge said, I think improperly, that our amendment was futile. It is not futile, because the case is governed, it seems to be, by LaFontaine. The LaFontaine case, as you probably know, then went to the factors that exist with respect to retroactivity. Those four factors, they're four principles, I guess you should say, that's the way they were described. Those four principles clearly operate in this case as no exception to the principle of incorporation that is reflected in the LaFontaine decision itself. The first of those principles is obviously, and it's the most important, clearly, is legislative intent, and that is whether there was meant to be, by legislative decree, an intent to apply these 2021 provisions retrospectively. There is no such clear intent. Clearly, the Michigan Supreme Court has made it clear that there has to be a clearly expressed intent to apply statutes retroactively.
I presume you don't buy the argument that 500.2111F something does not, and can you tell me why?
Yes. 500.211F 8 It says an insurer shall pass on filings in which this section applies. And it says in filings to which this section applies.
Yeah, I wondered about that.
And then you go to subsection 1, and you see to what filings this subsection applies to. And it says before July 1, 2020, an insurer that offers automobile insurance in the state shall file premium rates for personal protection insurance coverage for automobile policies effective after July 1, 2020. So that is the coverage of this statute. It applies to automobile insurance policies effective after that date. There is nothing in this case that involves a policy that is effective after July 1, 2020. Their reliance on this statute is seriously misplaced. So the first, let me say this about intent. There's something very unusual about this case and intent, and that is an interesting amicus brief that has been submitted in this case by 2 members of the Michigan legislature, signed on by 73 members of the Michigan legislature, all of whom indicate that there was never an intent in passing this statute, and I hope the court understands the speed and perhaps I can say lack of deliberation that led to these particular changes. But 73 members of the Michigan legislature have signed on to an amicus brief in this case, which have indicated that it was not their intent that this should apply to Ellen Ander.
Did they vote for the bill?
Pardon?
Did they vote for the bill? These 72?
It might be, I thought it was 73.
However many, did they vote for the bill?
Oh, I can't say, I don't know.
Okay.
But the fact is that there is nothing clear. The presumption, as you know, is in favor of prospective application only, and it takes a clear indication from the legislature. And as the Supreme Court has found, there is this legislature certainly knows how to make something retrospective, and it would have been relatively easy, it seems to me, to do so in this case, but they didn't. The second factor that exists under the second principle that exists under the LaFontaine test with respect to retrospective application is a question of whether there is, even if there is some reference to a past event that does not necessarily make something retrospective in application. There is no such thing unless you want to read into this. There is one, I guess there's one date that predates the statute, that is January 1, 2019, which happens to be the date that was used as a pricing mechanism for under 3157.10, I believe, or 7. But the point is, there was a reference to the amount of the bill at the time of January 1, 2019, the only date that I could find of any relevance that predated the statute. But that's only a date that was used to set the price or the amount that could be charged post. So it had nothing to do with a retrospective application. So the second factor, second principle cited in LaFontaine is irrelevant to this. And the third and fourth factors, and this is important to me because it involves a case that was decided before our original brief our original brief was filed, and that's the Buell case. The Buell case is obviously the most recent decision of the Michigan Supreme Court on the subject of retrospective application of statutes. The Buell case is dispositive, it seems to me, of both the third and fourth factors of what has now become known as the LaFontaine test, because what the court ruled in Buell, and I sincerely hope on the third factor, which has to do with the vesting.
The third factor is what?
Whether rights have
vested
vested.
Okay.
I hope the court can see the similarities between what the court was talking about in Buell and this particular case with respect to retrospective application, because in Buell, the Supreme Court found, if you recall, Buell was the case involving the application of 1402A, the statute which granted cities the right to claim the open and obvious danger defense. And the question became, can you apply this legislative amendment to a case in which the plaintiff was injured before the statute was amended? And the Supreme Court ruled in Buell, and I hope it sounds familiar to this case, to you, it would result, because retroactive application would relieve defendant of the legal duty it owed to plaintiff at the time the injury occurred. In other words, because plaintiff's claim had already accrued on the day she was injured, the retroactive application of the statute would effectively rewrite history as to the duty the defendant owed the plaintiff. Those words apply equally here. The defendant is trying to rewrite history. Defendants are trying to rewrite history with respect to the contractual arrangement that existed. The fourth factor, last factor that I'll talk about, is if where a statute is procedural or remedial, it's given retroactive effect. Buell addresses this issue as well, because basically because a right that has vested can't be characterized as procedure or remedial. And what the Supreme Court said in the Buell case on this point, a newly enacted statute or amendment should not be retroactively applied if in doing so it would relieve a party of a substantive duty. Again, a substantive duty that existed by contract 30 some years ago for Mr. Kruger, since 2014 for Ms. Andery. So I'd like to, I hope I've reserved enough time for.
You're 25 minutes in.
7 minutes, that's what I wanted.
Yeah.
That's what I wanted. So then I will sit down and respond later.
And is it Ms. McAllister we have arguing? Okay, thank you.
Good morning, Your Honor. May it please the court. And my deepest sympathies to Judges Markey and Patel. I hope you are feeling better soon.
Thank you.
I am representing here the defendant appellees in this appeal, and with me today is my partner, Joe Wheaton. There's a lot to cover, so I will do my best to get right to it. But I do think that we have to put everything in a bit of perspective before we get going too far into this. There's no question that the no-fault law is one of the most heavily litigated pieces of legislation that ever was in the state of Michigan, and that it is certainly endowed with many socioeconomic issues that impact our state. And the amendments, there have been 58 different amendments to the No-Fault Act over time. And in those amendments, each time there has to be choices made by the legislature among competing public policy choices. It was no different here. We had competing policy choices on, do we require everyone to purchase lifetime medical benefits, or can they purchase lower limits? What do we require in terms of bodily injury protection limits? Do we adopt fee schedules for the first time, or do we not? Those kinds of decisions are the ones that are left to the legislature under our tripartite system that we have, and should be here. I was struck as I was getting ready for the argument with a quote from a case with Judge Shapiro and Judge Markey. Actually, it was one of yours, the Gavrilides case that you decided just a few months ago, by the following quote: "Ideally, the best source of public policy is the legislature. By deferring to the legislature in matters involving complex social and policy modifications far beyond the facts of the particular case, we are not telling the parties that the issues they raise are unworthy of legal recognition. To the contrary, we intend only to illustrate the limitations of the courts in fashioning a comprehensive solution to such a complex and socially significant issue."
Well, let me stop you there, because I don't think anybody would argue with anything you've said so far. The question is whether or not, at least as I see it, you correct me if I'm wrong, there's a presumption of prospectivity in legislation is whether or not there are sufficient either explicit or implicit statements in this statute that make it retroactive. I asked
Let me
Mr.
start-
Gonzato about that one provision, and I got to tell you, I know these things don't control, but I read all the legislative analyses yesterday. I didn't find retroactivity mentioned once in these 50 or 60 pages. So help me with how we know the legislature wanted to make this retroactive.
Well, I guess I would disagree with the retroactivity label as a misnomer.
Yeah.
Because what the legislature did is it could have made the applicability of the act to be based on the accident date or the
No,
treatment
I
date.
understand. Let's not use the word retroactivity.
Yes.
Okay.
And what they decided to do is make it applicable to the treatment date. And in
The
section
date of loss,
31,
you're saying the date of loss is not relevant.
it is not relevant for this case.
Okay.
That's true. Because 3157 in subsection 2 and all the way through to subsection 14, all of the fee schedule provisions
Mhm.
indicate very clearly that the statute applies to future care and treatment and rehabilitation. That language is used throughout each of them, each of those particular sections. And that is consistent with no fault generally, because we know from MCL 500.3110 sub 4 that when we're talking PIP benefits, that PIP benefits accrue not when the injury occurs, but when the allowable expense is incurred. And the allowable expense here is the care and treatment expense that is subject to the new fee schedule. So they are not saying go back for the care and treatment that you already received and apply these fee schedules. The legislature made the conscious choice. They weren't going to go backwards, but they did say for care and treatment that occurs after the date of the fee schedule implementation, which is July 1, 2021, these control.
So let me ask, Mr. Granzato made the point that not just he, but everyone in the state who paid for PIP, their rates were actuarially determined in part by the possibility that some of them might need lifetime care.
And
So if in fact this is the case, why are not those premiums being returned?
Your Honor, everyone in the state just got a $400 check from the Michigan Catastrophic Claims Association
Is that
as a
it?
result of that.
That
That is part of it.
calculates to the years in which people paid for benefits that are no longer available?
It corresponds to the cumulative surplus that has been
And is-
attained.
Is there a
But it
record
is
to show that?
also,
Is there a record? to show
the
that?
MCCA brief in the amicus brief indicates that there is a $4.39 billion surplus amount that is generated as a result of the application of the fee schedules to accidents which occurred prior to the date. But that doesn't end the savings.
Okay.
And that gets us over to that section 2111 F8 that Mr. Granzato frankly misinterpreted.
Well, you got to help me because I can't make heads or tails of it.
I would be glad to help you
Okay.
because unfortunately, as an insurance regulatory geek lawyer, I have to get into that section. 2111 talks about these are the things that you have to do as an insurance company when you are filing and setting your rates. One of the factors, the new factor that has been added is in 2111 F8. And what that says is an insurer shall pass on. So that means the insurers have to start passing on in filings to which this section applies, which means in your new rate filings that you are going to make, because as he points out, this is for your future rates, savings realized from the application of sections 3157(2) to 12, which are the fee schedules, to treatments, products, services, et cetera, rendered to individuals who suffered accidental bodily injury in accidents that occurred before July 2, 2021.
So tell me what that means.
That means that there are savings that are going to be attributable to the application of the fee schedule to accidents that occurred prior to July 2, 2021, when those individuals seek treatment after July 2, 2021.
I don't understand.
So
I'm
for
sorry.
example,
Yeah, please.
I was injured in 1999.
Okay.
but I'm still seeking care related to the accident. When I go to the doctor tomorrow, my medical provider is subject to the new fee schedule in 3157. Instead of charging me $500 for my MRI, that doctor is now limited to a maximum charge of $250 in my example. That's a savings of $250. The savings attributable to the application of the fee schedule are $250. The insurance company is required to track those savings, aggregate them, and then in its new rate filings for the, excuse me, the new rates that it's going to file and charge in the future to its policyholders, it has to reflect that $250 in savings, as well as all the other savings attributable to the pre-fee schedule accidents, and pass that along in its rates. So instead of paying a premium bill of $3,000 when you renew your policy, you might only have to pay $2,275,000.
And that's for everybody, not just for people who were injured prior to 2019.
That is for people that were injured in accidents that occurred before the fee schedule, July 2,
So they get a
2021.
special rate reduction.
No, everyone, those are the ones who have the savings that are gathered by that section that are applied to your premium rates.
Yeah, but do they get the savings?
Everybody does.
So the savings are then applied to future policies, but they're based off of the savings that you're getting from people who bought policies before the statute went into effect. Is that correct?
Correct. That's correct. And bought before and had accidents before. So if there are savings that accrue because of application of the fee schedule to people who had accidents before the fee schedule went into effect, those savings have to be passed along to people buying policies in the future.
So those savings then are from benefit from here on forward.
Correct.
Okay. And how is that how does that not coexist with a finding of prospectivity?
All of the benefits, that section would be meaningless if
Why?
you only applied it to accidents that occurred after July 2, 2021, because there would be no savings attributable to accidents that occurred before July 2, 2021. If you look at the last language
I
in
hear
that
you.
section, Your Honor, this is tied to savings attributable to accidents that occurred before July 2, 2021.
Is there
So-
anything else in the statute that you believe indicates an intent for applying this to accidents that occur before the 2019?
The whole structure of the fee schedule, section 3157, ties it not to the accident date, but to the treatment date.
Okay. Anything else? I just want to make sure I've got it all.
I think you've got it all
Okay.
in terms of what we believe it is tied to. A couple other points, if I may, Your Honor.
Please.
And certainly I want to focus on anything that concerns the court. Couple of points I'd like to make also with regard to something that was kind of buried in your initial question to me, which is, hey, these plaintiffs would have paid for this premium and it's actuarially included. That's not the record in this case.
Well, there's no record.
Well,
Is there?
there's the record of the exhibits that were submitted to the court by both parties and the policies.
We're not talking about newspaper articles, are we?
No, I'm not talking about newspaper articles, but what I'm talking about is the record evidence that was submitted. Neither of these plaintiffs purchased policy. Neither of them paid a premium. Mrs. Andary was not a policy holder. She is covered by an insurance policy that her spouse purchased, but she never paid
So-
any premium.
So what is the significance of
Wait
that?
for the actual purchaser to bring a case? And this is not the
No,
place
I
to
think you
decide
could,
it?
I think you can decide this case, but I think it's important that you understand that the facts are not as Mr. Gonzalo represented.
Well, it
Because
either
he
matters
got
or it
up
doesn't.
here and said, hey, the facts are these people bought these policies, they paid this premium, and that is not true.
So my
Neither of them
question-
were purchaser.
My question is, why is that distinction important?
Well, I think, first of all, it affects the contract clause argument. You can't have a contract clause argument if you didn't have a contract to begin with, and neither of them had contracts which they purchased. But I think the contract
In other words,
clause
they're
argument
third-party
still fails.
beneficiaries.
I'm sorry, Judge Markey, I missed.
Yeah, you're basically, you're saying Mrs. Andary is a third-party beneficiary of that contract.
Yeah, she is a covered insured under the
Covered,
contract.
yes, it's a
But,
covered
yeah,
insured.
But
Right.
yes, but she is not a purchaser, which is what they were claiming. And so I think it does, though, affect the contract clause in terms of, because contract clause claims are based on, I have a contract and therefore I have a contract clause expectation. How do you have that expectation if you don't have a contract?
So tell us, we decide the contract clause in this case, or we can't?
You can and you should, and you can decide it on two grounds. One is it doesn't apply with regard to these two,
Okay.
but they've also brought a claim asking it to apply to everyone in the state of Michigan.
Uh-huh.
And as to that, there is no contract claim that applies. And the reason for that is severalfold. First of all, I think you have to look at the test that applies. And Mr. Granzato urged Your Honor, Judge Shapiro, to apply the language from your AFT case. And I guess I would have no problem with you doing that.
I don't know what I.
Because what you said is, quote, because a governmental entity is party to the contract and benefits from the impairment, we are to employ heightened scrutiny in our review of the statute. There's no heightened scrutiny
But
that
there's
applies.
there's still scrutiny. There's
There's-
still contract clause.
Right,
It's just
which
not
is
the absolute.
which is rational basis. And that's what Romaine said. It's rational basis,
And how can
just
we
like
do
due
that without a
process
record?
and equal protection.
I mean, I read Shavers last night.
Mhm.
There was enormous discovery. There were findings, there was evidence. Here, I read the briefs and it's newspaper articles and suggestions about what's happening in society without any findings. I mean, I don't understand how we're to determine whether this is a rationally based, certainly forget about the broader problem, but as to retroactivity, I think there's a real question in terms of the amounts of money that are being saved and whether this is necessary to preserve the system and its effect on the medical system. How are we to do all of that without any record?
First of all, Your Honor, when you're dealing with a challenge, a facial challenge, you don't need any discovery. We've put that in our brief. Secondly, the test is not whether the legislature was right or wrong
Of course.
about whether there are savings or not. So we could spend the time that they spent in Shavers, generate 135 boxes of discovery, and have the exact same thing happen, which happened in Shavers 2, which is nobody ever looked at the record and it wasn't even mentioned in Shavers 2 what the record was. They only looked at what the statute was and the fact that the parties decided on the law, and that's what the court did. The third thing is the kind of evidence that you're looking for would require us to go talk to all the legislatures and depose them. But there's this little thing in the Constitution called the Speech and Debate Clause, which I'm sure Your Honor is familiar with, or maybe not because it's such an esoteric thing that I at least had to look it up and see what the heck it was. But it says you can't depose sitting legislators with regard to what they intended on specific pieces of legislation. So I can't go out and depose these legislators as to, well, hey, what did you intend? Did you intend for this to be retroactive? Did you not intend for it to be retroactive? We have to draw the intent from the statute. We can also look at the legislative history. I don't know, Your Honor, when you said you spent time reviewing the legislative analysis, and I commend you for that because I know that's kind of a dry read. But I don't know if you also included in that our Exhibit A, which was something that I would ask you to take a look at, which is the House of Representatives Journal. And in the journal at page 635, you will find, first of all, an amendment being offered where someone offers on page 635, Representative Gay Donago, who was one of the signatories on this unverified, not under oath statement these legislators meant that under the case law you can't even consider. But Representative Gay Donago said, made a motion to amend the bill to make it so that it would apply to only accidents that occurred after the date it got voted down.
Yes.
And then did you notice that what happened right after that, the amendment? They instead said, we're going to amend the statute to put in 2111 F8. And we are going to say, we're not going to say that it just applies to accidents occurring after the date. Instead, we're going to adopt this provision that says, if you get savings that are a result of applying this fee schedule to accidents that occurred prior to the date, you've got to pass that along in the form of future rate relief.
Okay.
I think that is pretty strong evidence as to what was intended with regard to this bill. There is an entire argument in our brief about vested rights and whether we are dealing with vested rights, because the issue on retroactivity, LaFontaine, and the contract clause all depend on finding a vested right. We have demonstrated in our brief, controlling Supreme Court precedent, that they have not been able to take any issue with, that in fact, this is not a vested right when you're dealing with future PIP benefits that have not yet been incurred. Romaine says the Supreme Court held over 50 years ago that an injured party cannot rely on the level of benefits existing at the time of the injury as a legitimate contractual expectation protected by the contract clause. I think that is pretty clear. Romaine versus General Motors, which is one of those workers' comp cases.
And
that
there's no
Prince Edward
employee
argued.
involved in that suit.
In that particular suit, that's true. But the principle that this is a statutory claim and not a contract claim was decided by this court in Bronson, and that's controlling published case law and with control here. And in both the Rookledge, versus Garwood case and the Van Buren case, no one has a vested right to the continuation of an existing law, quote unquote. And in Rookledge, it's a general rule that what the legislature gives, it may take away. There can, in the nature of things, be no vested right in an existing law which precludes its change or appeal.
Can there be a vested right in the contract?
No, not,
Okay.
it depends on the contract. But in PIP benefits specifically that are as a result of a statute, which these are statutory rights, not contract rights, under this court's case law, those can be taken away. We're not really dealing with contract rights being taken away. We're dealing with statutory rights.
I don't know. I've sat through a million cases where insurers have told me this is a contract and it is to be interpreted as a contract. And today you're telling me it's of no meaning.
It's of course of meaning because of the fact that you could have a lot of additional coverages in addition to the mandatory coverages. But as to the mandatory coverages, I think Your Honor probably quotes back to them the Bronson Authority, and that's what we're dealing with is the PIP benefits here. So I'm sure Your Honor had a snappy comeback to them and said, well, what about Bronson? If someone argued that to you. And
I forgot about Bronson, but I appreciate you.
And you would be right. Can we talk about LaFontaine for just a minute? LaFontaine, first of all, not a contract clause case. Okay, so we're only dealing with a breach of contract type of case. And the issue there was the legislature, when it adopted the amendment to the Motor Vehicle Act, they did not include any language whatsoever that would tell us whether or not the new radius would apply to contracts entered into before that date and enforcing them after that date. That is quite different than what we have in this case, where we do have statutes saying treatments after July 2nd, 2021 are in fact subject to the restrictions. I'm sorry, am I running out of time?
No.
Okay.
Down a rubber.
Okay, I just want to make sure I don't want to try the court's patience, obviously.
I'm very interested.
Okay, great.
I'm sure they are too.
If not, I can, try a dance move, but I won't try the entertainment that we had in the
Okay.
lower court on this particular case in our Zoom bombing. The express language of the statute here it is applicable as we talked about in earlier discussion. But it also, if you go through the LaFontaine factors, the first, even let's say it fits this misnomer, I would say, of retroactivity, then what LaFontaine says is not that you, in the analysis there, what it says is you have to look at all four factors. And even if it's retroactive, that does not mean that you don't enforce it, because it says that the legislature can still enact and enforce retroactive legislation. It doesn't preclude that from happening. And when the legislature does that, then what you're left with is you're kicked back over to, is it a contract clause violation? And that's what happened in the AFT case, because in this court said in AFT, and the Supreme Court affirmed on this basis, hey, if you're talking about a situation where the law says you can't do something that your contract would permit, then you're no longer talking breach of contract, you're talking a contract clause claim. And so LaFontaine, first of all, we have factor one, which says you don't have it applying. If it's going to apply retroactive, you have to have language saying that. And as I pointed out, we do have language saying that. Second,
The language saying that is 2111(1)(f), right?
F8 is part of it, but also the language of 3157.
Okay, got it.
Which I don't know how else you can interpret it when it says treatment rendered after July 2, 2021, and that's what all these plaintiffs are suing for. Secondly, they made it clear that just because it relates to an antecedent date, that does not mean it's improperly retroactive. And that's what we have here. Just because the accident was the antecedent date does not mean that it's improperly retroactive. And that's particularly true of PIP benefits, which the legislature, and if you look at the Oak Park versus Buell case, both say causes of actions don't accrue until you incur the benefit. Oak Park says if your causes of action accrue and the statute doesn't apply to benefits that haven't accrued yet, it's not a retroactive statute. So you put those two together, you don't have a retroactive statute.
Can I take you back to the beginning? Because I'm still confused
course.
about the 111 statute that we're talking about.
Well, don't feel bad, Your Honor, because that's how I make my living, is interpreting esoteric insurance statutes.
Okay.
So
So I'm still not clear how the language purports in any fashion to return premiums paid to those who believed that they were paying a premium for lifetime benefits and were charged accordingly.
I'm not saying that, Your Honor. What I'm saying is this section demonstrates that the legislature knew and intended.
I understand,
That-
but what I'm
that's
asking about
what
is
I'm
what happened to
asking.
that money? And why aren't the people who paid it getting it back, since they're not getting what they paid for?
Well, first of all, if there's ever a complaint filed that seeks that, I'll have some good arguments on it, okay?
I'm ready to hear them.
And secondly, the MCCA premium assessments went from $220 per vehicle, dropped down to $110 per vehicle, and then the last 2 years has been $86 per vehicle. That is a substantial savings, which every driver in the state of Michigan has enjoyed, in addition to your $400 check that every driver who is insured as of a particular date enjoyed.
Okay, and it's
And
your
there are-
position that that's equivalent to all the premiums that were paid by everyone in the state for lifetime benefits, which they no longer can receive?
Of course not, Your Honor. I'm
Okay.
saying that there is savings being generated, that the legislature was correct, that implementing savings, that implementing reform would lead to savings. And it in fact has led to savings. I'm not here saying
We know
it's a
that.
one-to-one,
Okay, well, this is where we
Basis.
get into the record issue. I mean, I don't know what, but okay, fair enough.
but again, the legislature only has to reasonably and rationally believe that what it's doing is going to lead to
Okay,
savings.
I get that.
And if you're doing a fee schedule, how can you not rationally believe that that's going to
Could
lead
we
to savings?
constitutionally have a fee schedule on insurance rates?
It depends on whether
We do
they
it
are
retroactively?
confiscatory or whether they are, there's a whole lot of issues on whether that would constitute a regulatory taking. And without a lot more hypotheticals and consultation with my clients, I don't think I'd be able to answer that for you today, Your Honor.
Fair enough.
But Your Honor, the other point that I think is being lost is these insurers are not off the hook for lifetime benefits. Under the statute, lifetime benefits continue. They are still subject to paying reasonable benefits for reasonably necessary care. What this debate is now is how do you define what a reasonable amount is for the reasonable necessary care?
But the new
they
statute
still
doesn't
have-
define that, does it?
I'm sorry, Judge Patel, you broke up in the first part of that.
I said the statute doesn't define reasonably necessary care, does it? At least for
It
my.
doesn't define reasonably necessary care, but
Or
it does
reasonably necessary cost.
define what a reasonable amount is by saying if you go over the fee schedule amounts, that those are not payable. And I
Because
would submit that that is saying what is a reasonable amount. That if you are, for example, billing 3 times what Medicare would have for a particular service, the legislature is telling us that that's not reasonable. That's my
Well,
interpretation.
walk me through your analysis of how you think that that this statute defines reasonably reasonable amount for treatment or training. Because as I read it, in 3157.1 says that a provider can charge a reasonable amount for the treatment that they're providing. And then the rest of the statute doesn't mention reasonable amount again. It simply talks about what they can recover as payment for and reimbursement. So those two things seem to be distinct concepts to me. So can you explain to me why you think one informs the other?
Sure. And it is definitely my interpretation of the statute. I think that what the legislature was saying is this is what we think is a reasonable amount. And these are the fee schedules that we think are appropriate to bring down the cost of no-fault insurance in Michigan. They do not say specifically, we view this as the reasonable amount. So I agree with Your Honor to the extent that there's nothing that says that explicitly in the fee schedule amount. But that's how I would interpret the statute is this is the legislature telling us what they would view as a reasonable amount.
Because here's one concern that I'm having. We have these contracts that people purchased, and it talks about they're purchasing PIP coverage, and the coverage that they're buying is for the reasonable amount of medical services, right? So the contract talks about the reasonable cost. But then we have this new statute that kind of is divorcing how much a provider can be reimbursed from reasonable cost. So how does that impact the contract that was actually paid and bought for?
My concern would be that I wouldn't divorce the two as Your Honor is doing in your hypothetical to me, because I think that this is the legislature defining what they would view as a reasonable charge for the various services that are rendered.
But you agree with me that the
But I
statute
would-
itself doesn't say that,
I
correct?
do agree with you on
Okay.
that, Your Honor. I do agree with you on that. But I also agree that, or I would also note, however, that the legislature is also, or that a policyholder, when you go to buy a policy, you're also buying the statutory mandatory no-fault coverages. Those are the ones you have to buy. And under Michigan law, Supreme Court precedent, if you're getting statutory benefits and that's what you're talking about, those can be changed by the legislature. And there's no case that they have cited to the contrary. Just like Mr. Granzato said that there's cases going both ways with regard to workers' comp. Don't you think if there were cases going both ways on the constitutionality of work comp, they would have cited one in their brief? this is the same system we have in the workers' comp system. It's just a different fee schedule. The courts have upheld the workers' comp fee schedule and application of the same kind of system, no fault system in the context of workers' comp for decades. We're just now saying we're going to apply this same kind of system fee schedule with regard to no fault.
But it's a little different,
public
right?
policy issue, not a court issue.
And I could be mistaken about this, but with workers' comp, the contract at issue is the employment contract between the employer and employee. And that defines the employee
No.
relationship.
No.
And then the workers' compensation benefits flow from that. Like then whether it's the insurer or the employer, like they have to pay the workers' comp, like they're responsible because of this employee-employer relationship, they're responsible for paying the comp benefits.
I would respectfully disagree. The only time that would be true, Your Honor, is if you've got someone that's operating without insurance. Everyone in the state of Michigan is required to have workers, all employers are required to have insurance for their employees, as I'm sure Your Honor is familiar. And same thing is true, of course, of auto. You're required to have auto insurance. The policy runs to the employer and covers the employee who is working for the employer. Just like Dr. Andery purchased an insurance policy, which doesn't list Mrs. Andery on the policy, but yet provides the coverage that leads them into court today. So it is in the workers' comp system, it really is really perfectly analogous, in my opinion, to the situation that we're dealing with here today on this case in particular.
So you're nearing the end of your time. I frankly started a little late. You may have already used up your time, but if you have something else you want to cover, it's an important case. You take a few more minutes and then we'll get Mr. Granzato back.
Okay. Thank you, Your Honor. And I appreciate the panel's engagement throughout and putting me through my paces. I appreciate that as well. I would just conclude by just 2 points. Point one, there's a presumption of constitutionality. That didn't come across at all when you listen to Mr. Granzato's presentation.
Okay.
And that's very important to the contract clause. Secondly, in the event that you want to say that the trial court abused her discretion by not letting him bring the LaFontaine claim forward, I respectfully submit that it is still futile, because you are not dealing in this case with vested rights. You're not dealing with contract rights that are optional. You're dealing with mandatory statutory benefits. And this court has a controlling case that says that, the Bronson case.
Does the contract, I understand the comp cases are not contracts with employees, so they're a little different, but I see your point. I forgot what I was going to ask. How do you like that? Give me just a moment.
No problem.
Oh, is there anything in the contracts, the policies that says in the event the Michigan legislature changes anything, your benefits may change?
Some of them do.
To the ones at issue here?
I honestly don't recall without looking. But I know that some of my clients have them, some don't. But we don't view it as outcome determinative on any of the issues.
Okay,
Okay.
thank you
Thank
so
you.
much.
Thank you to the court for
Excellent
your
argument.
attention.
Mr. Granzato, you have a few minutes and, I'll be soft on stopping if so long as you're rebutting.
The answer to your question is, your last question, these contracts do not have the provision you're talking about that could possibly change there. I have seen in other cases such a contract, but this one does not have it. Now, let me talk first, if I can, about this intent as it applies to the retroactive applications of these statutes. Ms. McAllister has first suggested this 211F as an intent, as an indication of intent. Remember one thing, the presumption and the legislature presumably knows this, the presumption is that a statute is to be prospectively applied only, which means the onus is on the legislature to clearly manifest the fact that they intend to apply this to something that has taken place years before.
Mr. Gonzato, in order to accept your argument, we have to first accept that these changes are retroactive. And to me, that's a big sticking point. I understand that the rates that may be payable as the costs are accrued, which has always been the case under no fault, you pay them as accrued. You don't say, well, I'm going to have these expenses down the road. I've incurred them now. And it just is like when you bought the policy, when they had the policies in 1999, the rates that were paid were what were reasonable at the time. Obviously, those have changed to become a lot more, and they've been paid a lot more for a lot of these PIP benefits. But I'm hearing your constant theme that we are to automatically accept that this is a retroactivity issue here, when I'm not at all convinced that it is. The event is antecedent, but the payment of the benefits is going to change prospectively as they are accrued, which has always been the case under the No Fault Act.
But I have two important responses to this.
Please,
One is that
please.
the rights vested long before.
Well, that's if you assume that there's a.
The second point is something I don't think I accented enough in my brief, and that is what LaFontaine says about what is, in essence, to be considered in the retroactivity. What you're suggesting, Judge Markey, and what Ms. McAllister suggested, is that these benefits accrue as they are paid, and it's the date of accrual that determines whether this is prospective or retrospective. I would refer you back to what the Michigan Supreme Court said in LaFontaine, because here's what they said. The Supreme Court specifically said, and this is again based the application of a change, a legislative change in a provision that affected a contract. The 6-mile radius will govern the agreement unless the 2010 amendment expanding the relevant market area is retroactively applicable to the existing dealer agreements. So what's retroactive under LaFontaine is not the payment. It's whether it was intended by the legislature to be retroactive to the agreement, not the payment. This is a very important point.
By that.
And I'm sorry for making your argument, but in Buell, I mean, the cause of action did not accrue until the injury occurred.
That's correct. That's correct. And this injury, obviously, these injuries occurred years before. Let me talk about her position on intent, because first of all, we have the two most recent Supreme Court cases on intent and retroactivity, and they both said the same thing, where the legislature has given immediate effect. This is an indication of prospective application only. And that is exactly what we are dealing with here. We are dealing with a statute that was given immediate effect. And that immediate effect, by the way, completely undoes what Ms. McAllister has tried to suggest to you as an inference based on 3157, because what she's citing are all the provisions in 3157 that say, as of such and such a date, for treatment rendered after July 1, 20, whatever. Those are, she says, those are indications that it was supposed to be applied to people like Ms. Anderett or Mr. Kruger. But you have to understand, this statute was passed in 2019. It was specifically in these dates were included as to when these things would kick in. So the simple point is, these dates that Ms. McAllister is relying on, these dates, they don't answer the question, they beg the question. Okay, it kicks in as of 2021 or 2020 or 2022, but the question still becomes, did the legislature intend that these things apply to these accidents that occurred 30 years ago? And that's, as you noted from your review of the record, that's something that was never addressed. So obviously the concept of intent has to be clearly manifested. These inferences, I mean, you know, a great lawyer can look through this and find something that seems to, well, it suggests that this is supposed to, but that's not the way it works. The fact is the legislature knows how to make something retroactive.
And they know how to fix the statute if it's not being interpreted as they meant it to be.
I didn't hear.
I said, and plus the legislature knows how to change the statute if it's not being interpreted as it was intended to be.
All I can tell you is, if this is clearly manifest intent, then I think a lot of other cases are going to have to be reexamined. Let me just say, finally, the Romaine is not a contract clause case. Romaine is not, and the reliance on Romaine is kind of baffling to me, because in Romaine, the court said the retroactive liability imposed by the change of statute does not abrogate a vested or contractual right of the employers, since workers' compensation benefits and liabilities are statutory in origin. The reliance on Romaine is completely wrong. The fact is that we do have rights that exist only because of a contract, We wouldn't be here if we didn't have a contract. So the fact is that both the contract clause and the LaFontaine incorporation concept exist in this case.
Thank you.
Thank you both very much for excellent briefs and excellent argument in an important case. Thank you.
I agree. Thank you.
We'll take a moment or two to allow those observers who wish to leave to step out of the courtroom, and then I'll call the next case. Thank you. And thank you all who came to attend to watch the proceedings. I'm going to wait for Judge Markey to return, and then I'll call the case. Thanks for your patience. And there she is. Thank you, Judge Markey. Very
Just
good.
grab a
All right.
folder.
The next item on today is number 2, and it is People v. Claudel Turner, 357699. We have both parties having preserved. And is it Mr. Stabline? Stabline, please go ahead and proceed.
Thank you. I would like to reserve 5 minutes for rebuttal.
Okay.
But I think I can keep track of the time. The other question I have, Judge, is the other learned counsel before me were addressing the screen when speaking to Judge Patel or Judge Markey. I don't know that the camera is coming from there, so it may appear a bit strange to them. So I'm apologizing if it does look weird. So, Your Honor, the fact is that, and I'm going to address the case law that was cited by the prosecution in their response to our appeal. And they first rely on page 18, where the prosecution says that the deputies in this instance had the probable cause to arrest Mr. Turner from the outset for the fact that they stopped the vehicle and he was driving the car. The prosecution wants to argue now, and this is was never argued in the trial court, but argue now that they had probable cause to arrest him. and cite the court to Hine versus North Carolina, which is a United States Supreme Court case. That case, Your Honor, is inapplicable to the fact scenario that we have here, because in that instance, Hine, the defendant, was challenging only the stop of his vehicle because the officer mistakenly believed that Mr. Hine had committed a civil infraction. One taillight was out on his car, and the taillight, the statute in North Carolina only mandated one taillight, not both. And therefore, he did not commit a civil infraction, and his challenge was to the officer's mistake of law. And in that case, they found that the stop was reasonable, but those facts have nothing to do with our case. And in regard to the other case cited by the prosecution, they cite the Hill versus California case, a 1971 case. Again, it's significantly distinguishable from the case that is before the court here, because Mr. Hill was not arguing that there was a mistaken identity as it applied to him. He was not arrested. It was another person that was arrested. The search at an apartment was conducted of the arrested person and the entire apartment. Hill, and then evidence was discovered that they used against Hill in the trial, but not the person who was actually arrested, who was not a defendant, apparently. Hill was arguing that Chimmel versus California, the Supreme Court case that limited the scope of a search incident to arrest to the defendant's wingspan, applied to his case, even though it had been decided subsequent to his conviction, but while his case was on direct review. The court concluded that it did not. But the facts of that case do not apply to what we have here, because Hill was not challenging the fact that they arrested the wrong guy or anything of that nature. He was challenging only the fact that the search was in excess of what was allowed under Chimmel, which didn't apply to his case. The ultimate touchstone of any search and seizure, as you know, Your Honors, is the reasonableness of what the officers had done. And that reasonableness is going to have to hinge on the facts of our particular stop. And so that's why I don't want to bore anyone with the facts, but and I know the court is.
No, this is a case where the facts are quite relevant.
Thank you. And so what the officers had is that they had spoken to an anonymous person. So that person is never identified, who said that a person named Michael Sullivan, and they got a particular description, who was a black male that had dreadlocks, was driving a Jeep in the southeast part of Pontiac, and that person had a gun in the car. The officers see a Jeep. Okay. They then.
Counsel, I want to interrupt you. Is our understanding of the informant statement based solely upon the police officer's testimony, or is there any other evidence of what?
No other evidence of what the informant said.
Thank you.
And there's no evidence that the informant was reliable, telling the truth, anything other than they discovered a very common vehicle in the same part of Pontiac as the informant had said. They stopped Mr. Turner. Mr. Turner then what happens is that the deputy gets out of the car, he approaches the driver's side. There's a second deputy that approaches the passenger vehicle. Mr. Turner is the only one that's in the car driving it. He has his hands up at the time that the officers come. The first thing that after he asks Mr. Turner to roll down the window, the first thing the deputy says is, "Do you have any ID?" And Mr. Turner replies, "Yes, I do." At that point, the other deputy on the other side says, tell him to turn the car off. He has him turn the car off, and he tells Mr. Turner he's going to get him out of the car. Up to that point, the officers' actions are all justified under the Constitution. Mims, Pennsylvania versus Mims, a long time ago said that the officers may ask a driver to get out of the car on a traffic stop. In doing so, what happened after that is the unreasonable actions of this particular deputy, who then takes Mr. Turner out of the car, immediately handcuffs him behind his back, and rather than claims that he does a pat down, but if you look at the video, which is part of the evidence in this case, he immediately goes into his pockets. Mr. Turner is wearing sweatpants, goes into his pockets and pulls out money that's in both of the pockets. the prosecution attempted to argue at one point in its brief, and I believe that page 25, that there were two different bulges that the deputy talked about. And that is not supported by the record. The deputy says that he had seen a bulge when Mr. Turner, when he had Mr. Turner get out of the vehicle. He went right to that area and discovers that it's cash. It's nothing else. And obviously possession of cash is not a crime. Mr. Turner still has driver's license, which is in the center console of his car. At one point, one of the other deputies asks him if he has a valid driver's license. Mr. Turner says, yes. The deputy asks him, where is it? And he says, it's in the console of my car. I'll get it. And they stop him. They say, no, you're not going to get it. At that point, the officers then take Mr. Turner off camera and conduct then a full search of his person, taking his pants down and retrieving narcotics and a scale. Of particular note is the deputy testified at the evidentiary hearing that he felt what he said was a hard piece of plastic or something when he continued this pat down of Mr. Turner. That was not something that he had observed before. This is while he's continuing this search of Mr. Turner. And in doing so, he testified that he had no idea what it was, and yet then reaches into the crotch area of Mr. Turner's pants and retrieves a scale, and then subsequently they discover narcotics. The fact is, Your Honor, the reasonableness of what the deputy did is at issue here. And my argument is that the deputy exceeded the scope of what the stop was for. It's an investigative stop. And numerous courts, the United States Supreme Court on down, have held that an investigative stop it has to be justified at its inception, and it has to be limited in duration and scope to either confirm or dispel the officer's suspicions. In this case, first of all, what the deputy did was immediately arrest Mr. Turner before he had determined anything, by placing him in handcuffs behind his back and searching his pockets. The fact is that arrest is not based on probable cause. There's no reason to believe that Mr. Turner had committed a crime at that point. And so he was unjustified in arresting him and searching him.
Your opponents argue, rather than looking at this as one whole story, they break it down kind of into slices. The initial stop, the getting out of the car, the pat down,
Right.
the handcuffing.
Right.
What's your response to the fact that they cite authority that each of those steps is acceptable?
Factually, that's not correct, because the handcuffing was first. That was the first thing that ever happened. The deputy has Mr. Turner get out of the car very slowly, grabs one of his hands, places it behind the back, tells him to keep his other hand up there, and then handcuffs him.
Well, what about this case that says when you have somebody come out of a car, the officer, for their own safety, can put them in handcuffs, which was news to me, but
that would not be justified, I don't believe, in every circumstance. But what we have to understand here is that the deputy, the whole issue in this matter is the identity of the person. They know they're looking for Michael Sullivan. They had already done their investigation before they even came upon this vehicle. They knew what Mr. Sullivan looked like. They had determined that Mr. Sullivan had a warrant out for his arrest, and also that he did not have a valid driver's license. I reached my 10-minute mark. But the point was that, so the identity of the person is the most important thing. And that's the first thing that the deputy asked him is, do you have any ID? And he says that he does. And before they even conduct this other, I'm going to call it the second search, we have a pat down and then he goes into to Mr. Turner's pockets. But before that, they determined that he says, I have valid ID. It's in the car. But they don't do anything at that point, even though he's handcuffed away from the car, not a threat. They've already patted him down. The reasonableness is not to now go continue a search of his person, but to verify his identity, as he has indicated. And had they determined that he was not Michael Sullivan, that he was in fact Claudel Turner with a valid driver's license, no warrants for his arrest, and not committing any crime, at that point, that would have dispelled their suspicion. And the subsequent search of him or the search that was conducted was without a reasonable basis under the circumstances. And
So you don't see this as a Terry stop initially?
I'm saying they had the right to stop him.
On what basis?
Well, number one, the officer testified that he was speeding. I'm not conceding that he was, but factually, I believe the trial court said that he was speeding.
Okay.
The trial court
Looked like he was going 27 and a 25. As I recall.
you look at the video, I can't conclude that he's speeding, but nonetheless, the court concluded that factual determination. From that point, that's a civil infraction, obviously. But they have information that the person may be possessing a gun. Fine. And the stop has to get him out of the car. Officer said he saw a bulge. He dispelled any further suspicion by reaching into the pocket where he saw the bulge and determining that it was cash. There's no other reason to search Mr. Turner at that point without identifying him first as being Michael Sullivan, the person that they're looking for. And they did not do that, even though they had ample opportunity and information to believe that he was in fact not Michael Sullivan. The trial court held it was significant, Your Honors, at the end of its opinion when the court said that Deputy Myers observed a bulge in defendant's pants and testified that he did not know if the object in the defendant's pants was a weapon. That's a conclusion of fact by the trial court. That does not give an officer the right to actually go into someone's pants and remove something from their pants unless you believe that the person is armed and dangerous. At the time that they actually did that Deputy Myers actually did that, Mr. Turner was handcuffed. He was back by the patrol car, not anywhere near his car. And that is the unreasonable actions of the officers under the circumstances in this particular case.
Okay,
Anything else?
thank you.
I'm going to reserve some time.
Any questions from my colleagues? No, all
Thank
right,
you.
very good. You do have time remaining for rebuttal.
Thank you.
Morning, Your Honors. Assistant Prosecutor Danielle Walton from the Oakland County Prosecutor's Office representing the plaintiff appellee, the people of the state of Michigan. And I just want to verify as my learned counsel that if I look straight at the bench, will I be looking straight to respond to? Yes. If I look at the bench, I'll be responding directly to you. Thank you. Great. So here, as defense counsel admitted, it's undisputed that the stop, request to exit the vehicle, and pat down of the defendant were justified. The sole question is whether the officer could legitimately remove the object, which turned out to be the scale with controlled substances from defendant's pants. And there are two grounds that the officer could have done so. First of all, the officer reasonably believed that defendant was Michael Sullivan, who had a warrant out for his arrest. And the officers did not determine defendant was not Michael Sullivan until after the controlled substance were already found. Now, defense counsel said it was unreasonable for the officers not to immediately go and verify and run a license through lien. However, the officer testified that he had been given information that this individual who he had been confronting would be armed. Then he saw the furtive gestures in the vehicle.
Well, I have a question about
Right.
those furtive gestures. I mean,
Right.
somebody says, show me your ID. And then when the person turns to the console, it's a furtive maneuver.
Well, the testimony was that the defendant reached down farther than the console.
Yeah, why would he have done that since he didn't have a gun?
Well, he had $7,000
Oh, okay.
at the bottom
That's a
of,
good reason.
and the officer the judge made a factual finding that there were in fact furtive gestures. So,
Okay.
so that was the judge's call. And then the officer testified that when he saw the defendant exit the vehicle, then he saw this bulge. And so that's why he put the handcuffs on him originally, because of this bulge. And then, and I also would note that even though the officer had grounds to conduct a full search because he believed that defendant was Michael Sullivan, he only conducted a pat down.
Well, you're saying there was probable cause at that point?
There was probable cause that defendant was Michael Sullivan
Why?
because he believed, as he testified, he matched the description of the information that he'd been given. Number one, by the citizen, but he pulled up a photograph of Michael Sullivan and he said he matched that description. So we look at California versus Hill, or Hill versus California, and say the question is whether the officer's mistake was reasonable. And in California versus Hill versus California, the individual who they thought was Hill actually said, "My name's Miller," and gave them an identification, said, "I'm Miller." But the court said in the surrounding circumstances, it was still reasonable for the officers to make this mistake. It's probable cause that it was in fact Hill. And if they had grounds to search Hill and grounds to search the apartment, then they could do that for this individual that they reasonably believe was Hill. And that's the circumstances in this case. But I have to note that the officer only conducted a pat down. So the question is, defense counsel concedes a detention was permissible. So if the officer conducted the pat down and had reasonable suspicion to believe that defendant was armed with something that could assault the officers, that the officer's actions was permissible. And what the officer testified, there's two different areas where objects were found. First, you can see in the video, I think it's 1335 in the video, you can see where the currency was found. And you can tell in the evidentiary hearing, if you look at page 42 through 43, that's where the officer said, "Well, I didn't know what that was." But the seizure of the currency is not disputed. Then you look at 1336 in the video, that's when the officers bring the defendant to the side of the car. They said they wanted to bring him out of the road. And that's when you hear the partner to Deputy Myers say, "Hey, you're going to pat him down." And that's when you hear it's either Deputy Myers or Detective Hendricks say, "Hey, there's a handle. I see a handle." And that's in the video. And Deputy Myers testified, "I believe that was a handle of a gun." Now,
What was it a handle of?
we found out later it was probably the scale, probably.
But it wasn't a handle, it was a scale.
Yeah, in the end, they determined it, but he looked at it and thought it was a handle. Now, defense counsel argues, well, he felt this hard plastic substance, but at the same time, there were multiple bulges in that area because we had the scale was found in that area and the controlled substances were dropped out of that area down to the bottom of the pants. So we know there are multiple bulges. Your fellow officer or you are saying that this is a handle. And then you had the furtive gestures and the information from the civilian. Any reasonable officer in defendant's shoes is going to believe at the least there's a reasonable suspicion that that is an object that can be used to assault an officer. And it's stated by the United States Supreme Court in Terry and Mims. These are situations, Terry stops that are fraught with danger. And I really like what the 10th Circuit said in US versus Roshan. It was almost identical circumstances to this case. And what Roshan stated is the Fourth Amendment is just not a game of blind man's bluff. It doesn't require an officer to risk his safety or those of fellow officers while he fishes around in the suspect's pockets till he can correctly guess the identity of and risks associated with the unknown object.
Well, why not put everybody in handcuffs?
Well, here, this is a circumstance where he saw a bulge. That's why he said he put him in handcuffs.
Mhm.
And that's reasonable because the first bulge he saw was the currency. There were $680 in one pocket. So that's probably a pretty big bulge. And then we have in the other area of the pants that we have the scale and the controlled substances. And so, and People versus Green says, if first of all, here's a circumstance where you had probable cause to arrest. But even if this court disagrees, the question is, was using handcuffs permissible? Yes, under Green, because they specifically believed that they'd seen a weapon. But let's assume for the sake of argument that you believe that he was arrested. He only patted him down and found at least reasonable suspicion there was an object in his pants that would be an object of assault to the officers. He doesn't have to know it's a handgun. He just has to believe that there's some object in the defendant's clothing that could be used to assault an officer.
Yeah, go ahead. I'm sorry.
No, feel free.
No, I think you just answered the question
Okay.
I was about to ask.
And because reasonableness remains the Fourth Amendment's touchstone, the constitutional inquiry turns on whether an objectively reasonable officer could have feared the detected objects might be used as instrument to assault.
You remember my question.
Okay.
It is different. So
Right.
is it your contention that, where does the prosecutor stand on? Was this initially, when the person was pulled over, a Terry stop or an investigative stop with probable cause to arrest based on the statements of the informant and the matching vehicle and view and appearance?
I think what happened was that they would have eventually arrested defendant, but they started with a pat down and a detention.
So
So-
what was the basis for the stop?
It was speeding as well.
It wasn't.
Speeding and as the judge found, it matched the information that they had been given by the individual, the civilian.
I gotta tell you, I watched the video. I have no idea how that officer could testify he was going at a high rate of speed. I mean, he passed through an intersection 2 blocks down the road and it seemed for about a second and a half at most.
Well, and then when he came behind him, he had to go 65 miles per hour
Yeah,
to catch up.
because the officer had stopped at a stop sign and waited some time. Okay. I mean, the judge made the findings they
Right.
did. I'm a
Right.
little baffled.
I was just looking at the speed on the in-car video and they were going up to, I think it was 69 to catch up with the defendant. It looks like he was going, I mean, and he said he could see better than what's portrayed by the in-car video. But that was the finding that was made by the judge. And I just would like to know, because the defense counsel has talked a little bit about the informant. I mean, the stop is uncontested. In Florida versus JL says, of course, it's only about the stop. And so the stop is uncontested. And Florida versus JL said, you know, we're just talking about the stop. If the officer had grounds to do a Terry pat down, we're not talking about that. And Florida versus JL also said that, you know, we are talking about a truly anonymous tipster, not a situation like Horton talked about, where we have a person that doesn't give his name, but he does give information face to face and also
How does
reveals.
that make it less anonymous if he doesn't give his name?
Because the question in Florida versus JL, the problem is they don't know the basis of the informant's knowledge. So it could be this informant's calling in based on hearsay from some other person.
So if this informant had called in and said, I saw a black man in dreadlocks in the 30s with a gray Jeep driving, doesn't give his name, but he's on the phone, good or bad?
That could, I mean, depend on the circumstances, but that wasn't Florida versus JL. And so People versus Horton specifically distinguished Florida versus JL to the circumstances in Horton.
Isn't the whole purpose to protect innocent people from wrongful accusations that get them into confrontations with police officers? In other words, if this man had not had any drugs, he would have gone home and that whole episode would have never been recorded or noted.
That's
But
correct.
nevertheless, he was stopped and put to a potentially illegal search. I don't understand. Okay, I mean, I don't understand how this thing is addressed simply by saying, well, we saw his face.
Well, that People versus Horton said there's a
It
difference.
says it. I can't figure out how they say it.
Right.
But yeah.
And, I mean, if you look at Florida versus JL, the problem is that the root of the problem that the United States Supreme Court says, and also in Navarrete, is that they want to know that the person has this basis of knowledge. And specifically, Florida versus JL stated that, hey, if you had an anonymous person stop to a police officer, give them this information, that may be a different situation. That was mentioned specifically in Horton by this court. That's why a distinction.
Okay.
But ultimately, I mean, the stop was uncontested, and that's about a stop. And the information that was given by the anonymous or civilian was only one facet of information that would give the officer grounds to believe that the individual was in fact armed. There was other circumstances at the scene. So if the court has any further questions or any of the other judges?
No? Okay. Thank you
Thank
so
you.
much. Very well argued. And you
Thank
do
you.
have time for rebuttal, counsel.
Thank you, Your Honors. The fact is that when prosecution relies on many pages of their brief rely on cases that are either from lower circuit courts of the lower federal courts and out of state courts, and none of those are binding on our decision here. The lower circuit courts have no binding effect, and this court in many opinions, as well as the Supreme Court of Michigan, has held that lower federal courts do not have binding. Their decisions are not binding on
Yes.
the decisions of this court.
Mhm.
The There is no record evidence, and the trial court did not find that there were multiple bulges. There is one bulge that the deputy talked about, and that's when Mr. Turner was taken out of the car. He dispelled any suspicion that there was a weapon by searching his pockets. And those are the facts that were presented at the preliminary examination and the pretrial evidentiary hearing. So to conclude that there are multiple bulges under the facts here is clearly wrong. The trial court is wrong in the sense that it concluded that the Terry pat down was justified, but makes no record or opinion about whether or not there was the initial pat down, which dispelled any suspicion that the officer had that Mr. Turner was armed and dangerous, and the second search of his entire person. They believed they were arresting him for driving on a suspended license. And clearly that is not based on probable cause because they didn't know who he was or didn't take any opportunity to find out who he was. So the officer's actions here were unreasonable under these particular facts and circumstances. And that's why I'm asking the court to overrule the trial court.
Any questions?
No, thank you.
No, thank you very much. Thank you both, counsel. That matter is submitted. Next on today's docket, item number 3, People v.
Judge Shapiro, could we take
Yes,
a
I'm sorry.
5-minute break? Could we take a
Excuse me?
5-minute break, please?
Certainly. All right, where the court's going to adjourn for approximately 5 minutes, and we will return and proceed then with item 3. Thank you.
Thank you.
Seated. Sorry, Judge, I just spoke to both of them. Judge Markey is on, and I believe Judge Patel is on. Very good. My apologies for the delay, and we'll get moving here. Our next case is item number 3, and it is People v. Tally Ellis, 357-388, and we have Mr. Middlestad here on behalf of the defendant. Prosecutor has waived.
Good morning, good morning still, judges. Yeah, I'm going to give you all a little bit of a whiplash here and say very little about my case. I think the brief pretty much addresses my argument, and we would ask that you reverse and remand for resentencing under People versus Washington. And with that, I will rest of my pleadings and answer any questions the panel may have.
Superb argument. Any questions from the panel?
Thank you. I'm all set.
Thank you, Mr. Middlestad. Sorry to keep you waiting. All right, that matter is submitted. Number 4 on the docket is People v. Bridges, 356-388, and I believe is Ms. Stout here? Has she checked in? Defense counsel Kimberly Stout? All right, if you want to see if she's in the hallway, and
I have information that she's appearing remotely, so I'm bringing her in now.
Very good. Thanks for reminding us.
Good morning. Can you hear me?
Yes.
Thank you.
Proceed. Thank you.
Thank you. The case has been called, correct?
Yes.
Okay. Thank you so much.
Oh, did I call it? I don't know. Item 4, People v. Bridges, docket 356-388. Sorry about that.
Thank you. Kimberly Stout on behalf of Latrice Bridges. Thank you, Your Honors, for being here despite not being well, Judge Patel and Judge Markey. And thank you for taking the time to listen to this argument. I'll reserve a few minutes for rebuttal, but I don't think I'm going to be that long. I'm waiving my argument, or I'm waiving my issue under ineffective on the 404B. I don't think that issue is appropriate, and I am withdrawing it, I should say. What I'm focusing on is the insufficiency of the evidence buttressed by the ineffective in allowing that hearsay in. The reason I'm arguing the insufficiency is I think this case lacked greatly in proof beyond a reasonable doubt, even in a light most favorable to the prosecution. If the court will recall the facts of the case, on January 1st in 2019, an African-American woman was pulled over in a vehicle, I believe it was an Edge, because there was allegedly no headlights on it. The police officer Koning's man, who's now a lieutenant, saw the woman very briefly, a minute to a minute and a half at the most. She got out of the vehicle. That's when he saw her face to face, but then turned and looked at the kids in the back of the vehicle, then apparently got back into the vehicle and backed up and pulled off and left the scene. A brief chase ensued, but it did not last long because of the speed and safety issues. 11 days later, this officer sees someone wandering down the street or walking down the street and decides he believes, and I quote the word believes because that was his testimony, that it's the same woman that he saw on the first who pulled away from him and resisted arrest. This woman, he testified, Koningsman testified, was African-American, 5'2" and 220. The day in court, he saw that she was between 5'3" and 5'4" and 180. That's a 1 to 2 inch difference in height, as well as a 40-pound difference in weight. Being 5'1", and I'm not disclosing my weight, I would be honored. I would be thrilled if somebody confused me as 5'4" and 40 pounds less than I weigh. He also testified that he saw the woman confront her children in the back seat, and these children were 4 to 5 years old. This is important. The court had asked me to send in some evidence, and unfortunately I couldn't retrieve it all. I did a FOIA to the East Point PD. I talked to my client, and I also called prior counsel. I tried to get the police car video the court asked for and the photos of the kids. I was only able to find one of the photos of the child. And as the court can see, the one child, she does, in fact, Ms. Bridges, have 2 kids, but they're not 4 to 5. She testified, and the picture shows one was under 1 year old and the other is 8. That's pretty hard to confuse with 4 to 5 years old. You can see in the picture that under 1 year old is a baby. The officer also claimed some similarity in their behavior by being argumentative and pulling out a cell phone, both at the July 1st encounter and the July 11th encounter. I don't think this is uncommon in today's world. It's frightening. There's a lot of fear of police encounters. So pulling out a cell phone seems to be commonplace and turns into serious evidence these days in cases. Ms. Bridges actually testified herself. She was able to account for herself on July 1st, and having testified that she never left the house after she returned home from work in the grocery store. She went to her mother's. She also confirmed that she had the 8-year-old child and the child under 1 at the time in 2019. There was a Ring video that she showed of the front door of her mother's house that did indicate she didn't leave through the front door anyways, the house that night on July 1st. It's interesting because her sister testified that she wanted to show that video to the police, but they weren't interested. It's troubling when further investigation does not want to be, is not followed up with. So in view of all that, it's my position that this is not sufficient to establish to the trier of fact beyond a reasonable doubt that all the elements of the crime have been met, that this is in fact the same person from July 1st, based on evidence that is so filled with holes. Buttress that with the hearsay evidence that the person who owned the vehicle that was being driven on July 1st that alleged that it was allegedly stolen or borrowed or used. The person who was fixing the vehicle claimed that it was her niece. It just muddies up and further buttresses the whole it's ineffective issue and shouldn't be considered in the sufficiency argument. So that's my argument. If the court has any questions, I'm happy to answer them.
I don't, I'm familiar with the record.
Thank you.
Okay,
Thank
thank you
you
very
very
much,
much.
Ms. Stephens. Appreciate your attendance. The matter is submitted.
Thank you.
Returning to the courtroom, we have number 5, People v. Jones, docket 357917. Here's a defense counsel is endorsed. Did he waive?
He did waive.
I think he waived. Thank you very much. Item number 5 is submitted on briefs. Next is 6. All right, item number 6 is Grew v. Gage Franklin Hamilton. It's item 6 and it's docket 357124. Yes. Good morning.
Good morning.
Good afternoon, whatever.
I was just going to say, I don't know what time it is, but I do know where I am in this docket, and I am representing the defendant appellant, Mimic Insurance Company. I'd like 2 minutes of rebuttal, which hopefully I don't need. Just very briefly, this case involves plaintiff's claim for underinsured motorist benefits under Mimic's policy. The trial court agreed with plaintiff that Mimic's policy is ambiguous, and therefore plaintiff was entitled to underinsured motorist coverage. The facts very, very briefly. Plaintiff and 3 other people were injured in an auto accident. The limits of the liability policy that covered the vehicle they were occupying were $500,000 per person, $500,000 per occurrence. Plaintiff and 3 other people agreed to apportion that $500,000, and plaintiff received $280,000 from that underlying policy. Then she seeks underinsured motorist benefits from MEMIC. MEMIC's policy has the same limits as the underlying liability policy, 500,000 per person, 500,000 per occurrence. Okay, there we go. Now, we all agree on the principles of construing contracts, insurance policies. When is there an ambiguous provision, when there is not? But I think we can resolve this just with basic rules for how you read any document that any lay person can understand. And I'm sorry I didn't remove my mask here. Let me do so right now.
You were nevertheless fully audible.
Okay, good, good. Well, hopefully I will continue to be so. The basic rules are you start with the beginning of a document and you start with the first paragraph. You don't leapfrog to a second or third paragraph to see if the document applies to you. Let's see if you satisfy the first paragraph. And when you read a particular paragraph, you start with the first sentence. You don't leapfrog to the second or third. And the final principle is when you have two statements joined by the word and, you have to satisfy the requirements of both of the statements. So with that basic understanding, let's start with the insuring agreement, paragraph 1, which begins, quote, subject to the definitions, exclusions, conditions, and limits of liability that apply to this part, unquote. I'm going to paraphrase the rest. MEMIC will pay damages caused by the negligence of the owner or operator of an underinsured motor vehicle. Okay, the policy defines underinsured motor vehicle. There are two parts to that definition. Part A defines an underinsured motor vehicle as, again, I'm going to just quote the relevant parts, quote, a motor vehicle which has bodily injury liability protection in an amount less than the limits of liability for underinsured motorist coverage shown in the declarations page, MEMIC's declaration page. That's not satisfied. The underlying policy has identical policy limits as MEMIC's underinsured motorist coverage, 500 per person. So that definition isn't satisfied. Doesn't matter if the plaintiff can satisfy part B, can't satisfy part A, it should be the end of the story. Now, plaintiff's response is, well, you know, that part A is confusing. It's ambiguous because it doesn't address the situation that exists in this case. What happens when you have multiple claimants to the underlying liability policy? You know, what about that? That does not render it ambiguous. I don't know of any rule of construction, contract construction case that says you have to put into a definition every single possible scenario that might occur in a particular case. What you do is you look at the rest of the policy to see if there's possibly an exception to the definition or it's somehow modified. And that is what plaintiff is trying to do here. She's going through different parts of the policy to say, oh, wait, here it creates coverage or it conflicts with the definition of underinsured motor vehicle. It doesn't. So let's go to which provisions plaintiff is relying on. Plaintiff looks at the second paragraph of the insuring agreement, which discusses set payments and settlements regarding the underlying liability policy. And she says, well, I satisfied all those conditions. There's a payment, you know, I got permission to settle the case. Well, the flaw with that is you don't leapfrog to the second paragraph of the insuring agreement until you satisfy the first paragraph. And you don't satisfy the first paragraph because you don't have an underinsured motor vehicle. Okay, so now let's go to the limits of liability section, which has a number of provisions, and plaintiff says, oh, I fit some of those. You know, I received a payment and, you know, I should be able to get an underinsured motorist coverage. Well, let's leave aside the fact that the title of this says limits of liability and MEMIC isn't liable. Well, let's gloss over that part. Let's go to paragraph 3 of that section. And let me backtrack to make sure I've got all the parts of plaintiff's argument. Plaintiff says that this limits of liability section contains set-off provisions that are designed to avoid duplicative payment for the same injury. And plaintiff says, well, I'm not seeking duplicative payment. You know, my damages, my bodily injuries, damages are far more than $280,000 that I received. Well, okay. Do you want to look at the set off provisions? Let's look at paragraph 3 of that. And it says, quote, and this time I will quote the whole thing. Underinsured motorist coverage shall be reduced by the sum of the limits of liability under all bodily injury bonds or policies, other than this policy, applicable at the time of the accident. So what do you do with that? You take MEMIC's 500,000 per person limit, and you reduce it by the limit of liability of the underlying liability policy. 500,000 minus 500,000 equals 0. End of story there. Now, in my brief, I discussed, which I consider to be an on-point case that involved an identical situation with multiple claimants to an underlying policy, liability policy, and virtually identical language that I just quoted, and that's in re Estate of Esmer. And I'm going to leave the full discussion there, but the point that I want to make out of Esmer is it had the plaintiff presented the same legal arguments. The decedent's estate only received $230,000. The liability policy was, just like in this case, $500,000 per person an occurrence, and there were multiple claimants. And the plaintiff says, well, you know what, you really should read this, your policy limit of liability section to mean the amount that is I actually received, the estate received, as opposed to what was available. And that was the term in that section, available. Here, it's applicable. It's virtually the same thing. And this court said, no, it doesn't. You don't look at what you actually received. The language says available. And the argument that the public policy argument that, you know, I didn't get fully compensated for my injuries by the underlying policy. Well, sorry, words of the insurance policy, the UIM policy control. Now, plaintiff's only response to Esmer is, well, it didn't construe the last provision that I'm relying on, and that's the other insurance provision near the end of the policy, the section on UIM policy. And plaintiff points to the last sentence. It says, oh, I put the last sentence of this paragraph in, you know, I can recover. Well, once again, let's start with at the very beginning of the other insurance clause. Quote, if there is underinsured motorist coverage with us, unquote. So there isn't underinsured motorist coverage under MEMIC's policy for the reasons I've just given. So you do not leapfrog to the last paragraph. And that's going to be the end of my extremely fascinating perusal of MEMIC's policy. If you're not buying what I'm selling, the second issue in my brief is whether MEMIC waived the right to arbitrate the amount of plaintiff's damages. I'm going to leave that to my brief. Does the court have any questions? Thank you.
No, very good. Thank you. And you have time for rebuttal should you need it.
Good. Let me take up my mask. Thank you. Good morning or good afternoon to all present. Your Honor, Joel Sklar on behalf of Alexis Rui. Our position is set forth in our brief. I do want to emphasize some points. In the trial court below, Farm Bureau, that was the Hamilton's insurance company, found an interpleader where they admitted liability and that the amounts of the $500,000 policy that Farm Bureau had were insufficient and adequate to, compensate all of the severely injured 4 claimants in this case. It's our position that and we agree that, that the trial court found is that you have to read the insurance contract as a whole to understand truly its intent. I understand that the position by MEMIC is that my client doesn't qualify as an underinsured. We disagree. One, because we think there are ambiguities when you read the contract as a whole. The first provision that defines underinsured does not talk about various claimants. It doesn't talk about what happens in a case like this when you have multiple claimants on a policy that's obviously exhausted. There's no issue the Farm Bureau policy was exhausted and too little. Intuitively, one would think that when you have an insurance contract in a declaration page, it says you have underinsurance coverage, that you would think you do have it. The language that the defendants have cited.
Doesn't subsection B of the definition of uninsured motor vehicle, doesn't that provide for what you say is in A?
Absolutely.
So you saying that A has no other
No.
meaning?
I think you have to read them conclusively and you have to read them together. And certainly A has a meaning. Again, what I'm advocating is that you have to read the contract as a whole, because if you do read the contract as a whole, it's going to be I've read this contract 30 times. I'm confused every time I read it. I find it ambiguous every time I look at it because I can give interpretations to the various provisions in different ways. And we do that. And we did that. We talked about the first paragraph or the first provision is how to define underinsured. We do talk about the limits of liability section. I do cite two cases, Bogey and Long, that basically say that what this provision does is it limits a duplicative payment, meaning that you can't get more than what our policy limit is. I'm not asking for more than what the policy limit is. In that same section, it does talk about claimants, and we'll say we're not going to pay more than the 500, our limit of liability, no matter how many claimants are. But that's in that section, and that section kind of indicates to me that yeah, you can get your UIM coverage, you can get up to 500 less of what you've received, and we argue that below, and the court appears to accept that below. The language that deals with the other insurance I found incredibly confusing, because I don't know, quite frankly, if I understand it, and I'm not going to tell the court that I do. But what I found interesting in that language was simply the last provision where it talks about other insurance, it talks about underinsured motorist coverage. And there's, I think it's disingenuous to say you don't have UIM coverage with us. You do have it. Whether or not you're going to qualify for it may be another issue, but you certainly paid for it. You certainly have it. You paid your premiums for it. And there is a section in the other insurance that says, however, any insurance we provide with respect to a vehicle the insured person does not own shall be excess over any other valid or collectible insurance. In this situation, Alexis Gruey satisfied those conditions. She had no license, no car. The coverage was because she was a resident relative of her grandparents. And so I think when you read this as a whole, it becomes remarkably confusing. And because of that ambiguity, the trial court found that we were entitled to the coverage. As to the arbitration provision, I'm not necessarily opposed per se to going to arbitration, but in this particular case, we filed a motion and attached proofs. I did an affidavit, I attached medical records to show that as a matter of law, the injury that was sustained by my client exceeded the $500,000. Essentially, she received $280,000 from Farm Bureau. Her injuries were far more than the $220,000 available under the MEMIC policy. And it would seem to be that under this particular language, where my client seems to have an exception carved out for her, she would be entitled to the excess, that up to the 500 under this particular provision. So I think, and again, maybe this is true of many insurance contracts, but in particular, this insurance contract, I think contains, when read as a whole, is going to cause confusion, especially as it was in this case. And I think the trial court got it right. We think, the defendants had an opportunity, or the defendant had an opportunity in the trial court to respond to my brief in response. They never did. They didn't argue that my limits of liability argument was wrong, or that the underinsurance argument was wrong, or that the other insurance was wrong. They did nothing. And I don't think you can create an appellate parachute to come here and say, well, wait a second, those arguments we didn't make below, we want to make them now. I think there's a consequence to that. And I think it limits the arguments the defendants have on appeal. And I would ask that the court affirm. I'll gladly ask any questions that the court would have.
I'm fine, thank you.
No question.
You guys are great. Okay, everybody stay healthy, please. I love no questions. No, thank you.
Ms. Nemeth, some rebuttal?
I think I addressed everything Mr. Sklar said about
Okay.
the policy. And again, yeah, my arbitration arguments, I'll put in my brief.
Very good.
Thank you.
Thank you both. The matter is submitted.
Thank you very much, Your Honor.
And we will call the next case, which is number 7, Whitlow v. Lewis, 354968. We have the appellee. Has anyone checked in for the appellant? Well, what time is
The
it?
appellant is appearing remotely, Your Honor.
Ah, excellent. That's the second time I did that. Thank you. We'll wait for Mr. Jarrett to appear.
Good afternoon, Your Honor. Can I hear you?
Yes,
Can you
we
hear
can
me?
hear you.
Can you hear me? I can hear you fine. Can you
Very
hear me?
good. Thank you, Mr. Jarrett. All right. Well, Mr. Jarrett, you are the appellant, so go ahead.
Your Honor, I do want to make my argument, but before I begin that argument, I'd like to make a motion to strike a brief, 46-page brief with 42 pages of exhibits that Mr. Sandweiss filed at 4:34 p.m. This past Friday, June 3rd. On the 3rd of June, I wasn't feeling well, so I kind of knocked off for the day around 1 or 2 o'clock. I went to bed. I didn't get out of bed for any meaningful period of time over the entire weekend. It wasn't until yesterday afternoon when I felt well enough to get up that I even realized that this brief had been filed. On June 1st, the court granted, in part, a motion filed by Mr. Sandweiss, which would have allowed him to participate in oral argument. And while I thought that permission was quite generous on the court's part, it didn't say anything about him being able to file a brief.
Well, Mr. Jarrett, let me stop you. I mean, I will, of course, consult with the other two, and we will make a ruling on your motion. But I mean, at this point, I think you should proceed with your substantive argument, and we'll consider that. All right.
Well, Your Honor, I will do as the court says, but I'd only say that by filing a brief that I haven't had a chance to read, I don't even know what Mr. Sandweiss might possibly say in his oral argument or how I should be prepared to rebut it. You know, I'm placed at a distinct disadvantage, even in presenting my initial argument, but I will go to the argument as the court directed me. Your Honor, I'd like to reserve, if Mr. Sandweiss is here to argue.
He is.
He is, I don't see him.
He's not endorsed for oral argument, is he?
No, we did. He's not,
We gave
he
him
was
a couple
granted
minutes.
oral argument.
Okay, I got an old docket sheet, I think.
Okay.
Okay, is he going to be permitted to argue?
Yes, he will argue.
All right, then with that in mind, I'd like to reserve 8 minutes of my time for rebuttal.
You bet.
There are essentially 3 issues that I raise in my brief. I want to touch upon all 3 of them. One of them does not address Mr. Keeler in any way, but addresses only the default judgment that the court did not allow me with respect to defendant Lewis. And so I will start with that. I set forth in my brief the series of requirements that the lower court judge imposed upon us in trying to get a default judgment. I filed my motion. It was supported by my client's affidavit. In the affidavit, she set forth what her revenues were. She set forth how the fraud committed by the defendants had cost her business, and I think was sufficient for the judge to make a ruling on the issue of damages and to enter the default judgment. Rather than to do that, however, the judge indicated that she wanted to have some further evidence to support what she called a whopper of a judgment if she were to enter it. And so she required my client to come up from Dallas, Texas for an evidentiary hearing. And in the evidentiary hearing, my client again testified as to what Safeway Transportation's revenues were, how they were to be computed, why they vacillated from month to month. For example, there are fewer school days in December than there are in other months of the year, and therefore fewer days for Safeway to have to transport students to and from school. She offered testimony with respect to how a minor accident had revealed that the defendant, Jay Lewis, had misrepresented the purchase of a new insurance policy for her fleet of buses and had produced false documentation to induce her into believing that she had insurance. But when it was learned that she did not have the insurance, Detroit Public Schools, DPS, canceled her contract that she had with or that Safeway had with the school district for over 40 years. She offered very clear and unambiguous testimony as to how her revenues should have been computed and why the contract was lost and therefore her damages. The judge was not satisfied with that. She then required us to produce certain financial statements. We did that for the 2 previous years, 2015 and 2016, prior to the cancellation of the contract, and for the first quarter of the year 2017. Throughout the entire proceedings with the judge, it seemed as though she was incredulous that this woman who lived and worked in Detroit was able to have a business that was literally a multi-million-dollar business on an annual basis. And she seemed incredulous that my client was able to have a contract that would pay her on a bad month, $368,000. And then she also interjected her own opinions about why my client should have used a firm in Detroit to try to restructure her debt and to get her some loans and that sort of thing. She questioned why my client went all the way to California to find the defendant and to rely upon his representations. She asked how closely he had been vetted before she hired him. None of those questions had anything to do with damages. None of those things had anything to do with my client's entitlement to a default judgment. The fact that the judge may have thought that my client acted imprudently, it was not an issue. And her opinion was frankly irrelevant. But it seemed as if we were playing whack-a-mole with her as we satisfied everything that she required in terms of testimony, in terms of documentation, in terms of everything that she wanted before she would enter an order for, quote, a whopper of a judgment that she was, quote, unable to sleep at night by trying to enter. She just found one reason after another not to accept what we had already done. So I think that, number one, it was totally improper for her to deny my motion for default judgment and to then dismiss the case entirely with prejudice. And number two, she did all that after we filed a motion to disqualify the judge because it was clear she was acting biased, not only with respect to her refusal to enter a judgment by default against a party who was not present, hadn't appeared, wasn't showing up for anything, wasn't disputing or contesting any of the things that we filed, and she just simply denied our motion. She totally ignored our motion for recusal. Now, the motion to disqualify her included things that I'm about to tell you with respect to the defendant Keeler. Now, defendant Keeler was an attorney or still is, as far as I know, an attorney in California. He filed an answer on his own behalf, but then he apparently retained Mr. Sandweiss to represent him. Mr. Sandweiss repeatedly and consistently disregarded court rules, disregarded the court's orders, attributed improper things or improper procedural things to me, which were totally untrue. One example is that, for example, on June 6, 2019, he filed a motion in which he said that he had not received my amended complaint, which we filed on May 16, 2019. We were able to show that Mr. Sandweiss downloaded that complaint, which he said he didn't have, he had never seen, he downloaded it on May 30th, 2019. Very similar to the things that he brought to this court's attention in his motion filed about 2 weeks ago. But in any event, our complaint very clearly alleged against, our original complaint alleged against Mr. Keeler, his knowledge and participation in a fraudulent scheme to get money from my client for services that were not being performed, for debt relief that would not happen, for negotiation of a more favorable insurance rate for her fleet of buses that never occurred, and that she forwarded money to Mr. Keeler's IOTA account, which Mr. Keeler allowed to facilitate Mr. Lewis's fraud and to lend some appearance of propriety to it, to my client. We alleged that Mr. Keeler knew or should have known that this was going on. We alleged that.
I think Mr. Keeler testified also that he kept some of the money for prior services, didn't he?
He did say that in his deposition, but then he claimed privilege when I tried to find out how much he had received and how much he had kept.
Okay.
He claimed that was attorney-client privilege, which is also part of my argument against him today. But in any event, just simply in terms of the complaint, we clearly did allege facts which if true would give relief. We allege facts upon which relief could be granted. Now, when Mr. Keeler's attorney filed a motion for summary disposition under C8, he doesn't argue anything other than we allege insufficient facts. The purpose of the complaint is to put the defendant on notice as to what the facts are that are alleged against him and the claims that he's called upon to defend against. Our complaint certainly sufficient, our original complaint certainly did that. And the amended complaint that Mr. Sandweiss claimed he didn't receive, although he had downloaded it 6 days before he filed the motion saying he hadn't received it. Our amended complaint certainly alleges facts and claims against Mr. Keeler. We allege a conspiracy to defraud the plaintiff. We allege legal malpractice since he was placed since the plaintiff was told by Mr. Lewis that Mr. Keeler was assisting him in the legal matters that were necessary for him to go forward with the debt restructuring, which he never actually did. We allege that he created a facade of legitimacy by allowing the use of his IOTA account and then wouldn't produce in the deposition that Your Honor referenced, wouldn't produce the IOTA records so that we could see what money was deposited and what money wasn't. So I think that the court clearly erred when she granted the motion for summary disposition and then dismissed the claims as to Mr. Keeler. Now, after the summary disposition motion was granted, the judge consistently had disallowed me to take Mr. Keeler's deposition. She first disallowed that, I believe, in February of 2016, when I appeared for of 2018.
Counsel, we're aware you didn't get the dep until after he was dismissed.
Yes, that's true.
We know about it.
And in the deposition, Mr. Keeler repeatedly relied upon his assertions of attorney-client privilege to avoid answering questions for me. Now, attorney-client privilege just certainly did not apply. Attorney-client privilege applies only to communications between attorney and client, which are to be confidential. So when I asked Mr. Keeler whether or not he had ever heard of the name Patricia Whitlow, and at first he said no, and then he said he vaguely remembered that Mr. Lewis had mentioned her name, that doesn't allow him to claim privilege, a vague recollection of some conversation about a person that he had testified he had not represented Mr. Lewis against. that doesn't allow him to claim privilege in avoiding my questions about what he did or didn't know about the Lewis Whitlow arrangement or how he figured into it. Privilege doesn't permit that. I asked for him to bring certain files of his representation of Mr. Lewis. The files themselves are not privileged. It may contain some privileged communications, but the files themselves are not privileged. He would not answer those questions asserting privilege. He asserted privilege when I tried to find out about other lawsuits that Mr. Lewis had been involved in. Certainly, if there were lawsuits that were related to the type of fraudulent scheme that my client was alleging, that would have been of critical importance to us. We couldn't get that information because Mr. Keeler asserted privilege, didn't produce the files, wouldn't testify to it on the assertion of privilege. He repeatedly asserted privilege throughout. So when I filed a motion to, number one, have the case reinstated because of his bad faith participation in the deposition and the extent to which we did receive some information showing and demonstrating his participation with Mr. Lewis, judge disallowed that. The judge disallowed me to receive a deposition with true and complete answers without improper assertions. What she did was she ordered that I produce the entire transcript of the deposition. And in the transcript, after she has the transcript, she says that both attorneys acted unprofessionally and therefore she's not granting relief to either of them. Well, she doesn't specify what she's talking about in terms of the unprofessional behavior or how that should impact my client. If I acted somehow unprofessionally, my client shouldn't be punished for that. I denied that I acted unprofessionally. But
Counsel, we've all read the deposition and we read it, and we understand that the issue you're talking about is not about who behaved professionally, but rather whether or not there were proper assertions of privilege and a full deposition. So you can move on from that point.
Okay,
we understand.
so then I need to only conclude that should not have been a basis for her to permit Mr. Keeler to get away with improper assertions of privilege. She says she's not going to let either party benefit, but it was really clearly only the plaintiffs that didn't benefit.
Mr. Jarrett, let me suggest, we understand your argument. Let's hear from opposing counsel, and you have plenty of time for rebuttal, okay?
Thank you very much.
Thank you, sir. All right, Mr. Sandweiss.
May it please this honorable court, my name is Stuart Sandweiss and I'm appearing on behalf of the defendant appellant Tyler Keeler. First, I want to thank the panel for granting oral argument. This has been a difficult case in the sense that there were problems with service. I identified those in the motion that we filed.
I got to tell you, counsel, your request to strike his brief and dismiss the appeal is not at all, what you stated in there is not at all consistent with our records of communications to you about the pending of the case. I just want to give you that up front. That's why the motion was denied. Okay, so it doesn't put you in the best light.
Well, I
let's
can,
proceed.
I would say I can, whatever, that's a separate issue, but I appreciate the oral argument and I did submit the brief on Friday and I hope the panel has a chance to read it. Let me just hit on a few high points. The issue in the trial court was whether or not the plaintiff failed to state a claim and whether or not the trial judge dismissed plaintiff's complaint on a C8 basis. Now, first time around, when we discussed it in chambers, I'm not sure if there's a record because I don't have all the transcripts. First time around, she said, go amend your complaint. Because the first complaint had my client's name twice. Once to say he's an attorney in California, once to say money went into his trust account. And we don't dispute either one of those. They amended. And then we get a complaint that talks about 4 or 5 causes of action and 3 counts or something, 4 counts, whatever it was.
Let me just get to the point here. Let's talk about the facts. What happened to the money? Why did your clients get to keep some of the money that were put in his trust account by someone who didn't have authority to put the money there as far as we know?
So what my client testified to, if I recall correctly, is that Mr. Lewis had owed him money. Mr. Lewis had him put money. The money belonged to Mr. Lewis. Mr. Lewis said this was put there for the benefit of Mr. Lewis. Mr. Lewis said, here, you take this, give me the rest. And that's what he did.
He gave Mr. Lewis his IOTA account number to do as he wished with?
No, he didn't give Mr. Lewis his IOLTA account number. He gave Mr. Lewis the money that came in there that belonged to Mr. Lewis. And Mr. Lewis said, keep this amount for you because I owe you money and give me the rest because he got the money.
Okay.
So he's the escrow agent. Okay. In terms of the account number, how he got it, well, when I have an IOLTA check, it's on every one of my IOLTA checks is my account number, and anybody can deposit money in there.
Okay.
And that's exactly what he testified to, and that's what happened.
We have a default that, at least as far as Mr. Lewis goes, establishes that he committed fraud, right? And this money that was part of the fraud went into your client's IOLTA account, some of which he kept. Why isn't that enough to get a deposition in which your client answers questions about it?
My client answered, we spent 3 or 4 hours answering questions.
Okay.
And Mr. Jarrett, after, the first issue is whether or not my client should have been dismissed on a C8 basis. Because I would tell you, and I've been doing this for 22 years, I've never seen a complaint like this that doesn't go through any of the elements of any of the causes of actions or notify my client what it is that my client was being accused of. I mean, there's no, Judge, you're asking me about the money in the IOLTA account. Show me something in the first complaint or the amended complaint that talks about my client converted money that's in the IOLTA account. It's not there. At the closest that they come to is they have a claim against for legal malpractice, which is.
So that's not too impressive.
Well, I'm saying you can't have legal malpractice against an opposing client when there's no duty to that client. And that's what, if you look at the transcript from the September 24th, 2019 hearing, that's
Produce a privilege law.
my client gave an affidavit.
Oh, come on.
He said
Affidavits are not good enough for a court to say there's a privilege. You have to give an argument as to why it's privilege, and the court may have to review the documents. This is not a free, here's a piece of paper that says it's privilege.
He said, well, okay, but first of all, this was after he was already dismissed. He was not a party. He was a witness, a fact witness in California without following the proper procedure. But he did it. And he said, I've got 5 emails between me and Mr. Lewis. That's it. That's the only documents I have. 5 emails. Emails between, unless somebody's telling me something different, emails between counsel and a client are privileged. Absolutely. I don't care what they say.
What if they're part of a conspiracy to defraud? How do we determine that based on the affidavit of someone who says it's not?
First of all, you have to have what's the fraud? There's no allegation in the complaint that there was a fraud. And to have a fraud, you have to have a representation of a previous or past fact. There's no allegation of a fraud in the complaint. I've gone through the complaint tens of times, and there's not one allegation in the complaint that said my client made, or even Mr. Lewis made a representation to the plaintiff. So in order to have a fraud, you have to have a misrepresentation of a past fact. You can't even, it's not even good enough to say, well, in the future, we're going to do this and this and this. You have to have
I understand.
Okay. So where's the fraud? Where's the allegation of a fraud? That's not even in the complaint. They talk about breach of contract. There's no allegation of a contract in the complaint. And you talk about civil conspiracy. Well, there's no where's the underlying tort for civil conspiracy?
Well, I think the underlying tort is apparently some type of conversion or fraud, right?
Well, there's no conversion pled.
Well, there's certainly plenty of evidence, but fair enough. Okay.
I mean, I'm only going on the 4 corners of the complaint. So once the trial court gave him 2 shots at it to try and explain what it is that what he was complaining about, trial court dismissed it, but said, okay, Mr. Keeler, I would like him to appear for deposition. And we said, okay, Judge, fine, no problem. And he came. We had just, it finally happened a couple weeks before COVID started. We both, Mr. Jarrett and I went out to California, and you've got the transcript and you indicated that you read it. It was an interesting deposition. I'll give you that.
I won't comment. Okay.
So the issue was, though, if the court's focusing on a conversion of money, this is the first time today, 3 years into this, that I've heard anything about a conversion of money. It's not in the complaint. It's not in any of the pleadings. It's not in his appeal brief. It was never brought up in the trial court. Where did the conversion claim come from? So I'm not really ready to defend that, but I mean, there is no conversion claim. The issue The other issues that he talked about in a brief was whether or not the trial judge should be disqualified. Now, I read through his motion to disqualify, which by that time, my client was not a party anymore. It was 9 months later. And it said, for the reasons in my motion for reconsideration. That tells me, well, you're trying to disqualify a trial judge because you don't like her ruling on a different issue. Where's the bias? Give me some evidence under the court rule, I think it's 2.003. Where is the analysis that shows why the trial court judge should be disqualified because you don't like her rulings? Right? And as I mentioned in the brief, she ruled against us on issues too, when it came to the depositions and the dates, and there's plenty of rulings against us as well. But I didn't ask to disqualify her because none of that, I can win arguments, I can lose arguments, but that doesn't necessarily mean a judge needs to be disqualified.
Continue, I'm sorry.
Yeah, and just a couple more points, and then I will gladly answer any more questions the court has. With regard today to the motion to strike the brief, again, this is another example of where is there a court rule behind your motion to strike? You have to have a basis for it, and there's no basis. I think you can submit an appellee brief at any time until the case is submitted. I think that's what the court rule says, and I think that's what the Court of Appeals.
That's what it says.
And I think that's what the procedures say. So I don't know where the basis is, but this is exactly what's been going on is we're making stuff up as we go along. And that's not the way this process works. In terms of the default motion against Mr. Lewis, I don't have the transcript from what went on in the colloquy between counsel and the court that happened almost a year to the day. I think it was 1 day off from when my client was dismissed. I don't have that, so I can't tell the court, say what the court did was, the trial court did was right or wrong. I can say that on the facts that I've seen in the complaint, I don't think there was a claim alleged against Mr. Lewis either, whether there was a default or not. A default means that well-pled allegations are true, and then a plaintiff has to prove damages. I don't think there was anything well-pled in terms of allegations of any contract tort against any of the defendants. And so I think that the trial judge was correct in saying that, hey, you didn't state a claim and you didn't prove your damages and so forth. But I was not at that hearing, so that's about as much as I can comment on it. Again, the only other thing I would emphasize is that this allegation about my client disregarding court orders didn't happen. Where's the court order? There's a order when we filed a motion to quash in terms of documents and stuff, and the trial court granted that motion. So where is an order? I'm still waiting for this order. Suppose this phantom order says you have to bring these and these and these documents. Just because Mr. Jarrett issues a subpoena, ducus tecum, that we objected to, the trial court ruled in our favor.
Why'd you object? Why'd you object?
To the ducus tecum? I honestly have to go back to the response to answer that question. But off the top of my head, again, this is going back 2.5 years, is that some of the documents were privileged. We talk about that. And if there is correspondence back and forth, it would be privileged. And it was and I think the example I used to the trial court was if something is and I think I just used it this morning also, if something is prospective, if my client comes in and says, you know what, tomorrow I'm going to murder so-and-so, I've got an obligation under the rules of professional conduct to notify somebody to prevent imminent harm to somebody else. If my client comes to me and says, last week I committed a murder, that's privileged. It's past. But
what if he comes in and says, I'm stealing a bunch of money and you can have some of it?
Past tense or future tense?
I don't know. I mean, I guess that's future. I don't know.
There's no allegations in this case of future tense. The allegations were, you did this already, the money was gone already. And even if there was and we deny that there's any wrongdoing over here. And Mr. Q had testified about the money and where it went. And Mr. Jarrett asked him that, and he answered those questions. You can review it in the deposition transcript.
Okay.
But to the extent that there's communications, I mean, he was asking him, he was basically doing a fishing expedition about, do you know about this particular case? And were you involved in this? And what's Mr. Lewis's current address? Or do you know his whereabouts? Was he involved in this? And my client said, one thing I remember very specifically a couple things I remember very specifically. At one point, I pulled out my laptop and I said, I'm going to look these things up. And I gave him a whole list of cases that he was involved in. I said, these are all public records. Why do we have to come to California to answer? Why do I have to come to California for my client to answer questions about things that you can look up yourself? They're public record. If he wants to testify about public record, no objection there. But Mr. Keeler was concerned about one particular transaction and whether or not a particular deal that was not public record that Mr. Lewis had been working on with somebody else, and he started wanting to ask him questions about that particular deal. And he says, I can't answer that because I don't want to lose my law license. If my client's talking about if something is not public and he's working on a deal, nothing to do with Ms. Whitlow. And it's right in the if you look in the transcript, he says, I can't possibly answer that without breaking attorney-client privilege. It's Mr. Lewis's privilege, and I'm not going to take a chance on losing my license. So if you know, I think the way this goes is he has to file a motion and say this and this is what I'm looking for, and then the trial judge makes a ruling, and the trial judge orders him to answer. Then okay, then he can, you know, then he has to comply with the order. But the trial judge never did that. So where is it that that he supposedly did something wrong? He's trying to protect his license, as I think every attorney in this room would do the same thing. If you've got something, if there's a question of privilege, err on the side of your client, and then let a court come and say, well, this is not privilege, you have to release the information, and then you're covered. And that's what he wanted to do, and that's what he did. So, and again, I remind the court that at that point, he was not a party. He was a fact witness in a state 2,500 miles away that was gratuitously giving a deposition that he agreed to. And that's what we said to the trial judge. She's going to dismiss him. Will you come to a deposition anyways? Yes, I will. No problem. And that's what we did.
Okay.
I don't know if the court has any, or if the other judges who are virtual have
questions?
any questions.
I have none. Thank you.
No, thank you very much for your presentation. No, thank
Thank
you,
you,
Mr.
Judge.
Samwise. Mr. Jarrett, do you want to give any rebuttal?
Yes, sir. First of all, Mr. Samwise has repeatedly misrepresented almost everything that's come out of his mouth. On September 24th, 2019, at the same hearing where the judge granted the motion for summary disposition, she then ordered this deposition, although I don't know what authority she has to order a California resident to appear for a deposition. She ordered it, and I accepted her order of that. In that same hearing, she also ordered that Mr. Samwise's client to produce all of the documents in the duces tecum portion of the deposition notice that I had repeatedly requested in all of the times I noticed the deposition. And if there was any claim of privilege for any of the documents that I requested, he was to produce a privilege log. And the documents were supposed to be produced, and the privilege log was supposed to be produced by November 1st, 2019. Mr. Samwise and his client produced nothing, no documents, none of the privilege logs. So we took the deposition as best we could. He starts asserting privilege for all sorts of things that clearly attorney-client privilege does not apply to. He asserted it even to whether or not he had any knowledge of my client's name before. He said it's privilege, that any communication he had with his client about it would be privileged, though he didn't establish anything. So if he produced the privilege log as the judge had ordered, then we might have been able to address these issues of privilege in advance of our trip to California. Mr. Samwise says that the money belonged to Mr. Lewis, and so he took what was owed to him per Mr. Lewis's instructions. So Mr. Keeler testified that he didn't know who had put money in his account or why. That was his testimony. And I believe it's implausible, but he says, I don't know who put that money in, and I don't know why it was put in, but I kind of suspected that it was put in by Mr. Lewis's instructions. Well, I asked, why would Mr. Lewis give instructions to put money in your IOTA? And he claimed that was privilege. So, this is round and round in circles. We're not getting anywhere with this information. He was not the cooperative witness that Mr. Samwise portrays today. He was very flippant and arrogant. He wouldn't answer anything. So I don't
Council,
know.
we've all read the DEP, and I appreciate that your fervor about it, but I think we understand the facts. If you have more legal argument to make, go ahead, but I don't think we need further description of
Okay,
the,
I just want to emphasize that Mr. Keeler's testimony with respect to the not knowing who was putting this money in his account or why. That's extremely important and is directly opposed to what Mr. Sandweiss is saying today. I asked for knowledge of Mr. Lewis's addresses. That's clearly not privileged. He didn't give it to me. So I have to go back to my original argument. I won't bore the court by going through it again. I appreciate the time in allowing me to.
Thank you, Mr. Judge.
Thank
Thank you,
you.
Mr. Sandweiss. The matter is submitted.
Thank you.
We have, I think, 2 more cases. Judges are prepared to press on at this point, or anybody want to break?
I'm fine.
Okay, thank you. All right. So item 7 is submitted. We go to item 8. Estate of Benini versus Samir Al-Swab, MD. Appellant, go right ahead.
Good afternoon, Your Honors. It's nice to be here today. It struck me as I was walking up that the last time I stood at a podium in the Court of Appeals was the day I was sworn into the bar. So
Welcome back.
nice to be back. So I think this issue of the loss of opportunity, I didn't even say my name, Rachel Radden for the plaintiff appellant. I think this issue of the loss of opportunity to survive can either be quite complicated or rather simple. I think the trial court acknowledged the complexity of this argument at oral argument, which perhaps explain why, in my view, he arrived at the wrong conclusion. So I'm going to try and keep this simple and hit on a few points, and I'll try and reserve the majority of my time for rebuttal in case arguments go down the more complicated route. So I'll start with what the parties here agree on. The parties agree on the law applicable to this case. This is the loss of opportunity to survive case. The parties agree that the opportunity to survive or to achieve a better result has to be diminished by 50%. The parties seem to agree that the statute does not require that the initial opportunity to survive be greater than 50%. And the parties
So in
agree.
other words,
I'm
the
sorry.
parties are both agreeing that Fulton controls?
Yeah, well, the party, I don't want to get too far afield. Yes, they do. I think there's a little bit of a debate on appeal about the calculation under Fulton, because at the trial court, and I said this at oral argument, and I didn't hear any correction or objection from trial defense counsel. My argument at below and still here is that it's a 50% reduction. It is not a 50 percentage point reduction.
Okay,
Yeah, and I think there's a little bit maybe of a shifting position on appeal from defendant's perspective. The trial court didn't even get into running calculations at the trial court. But to that point, I mean, I would just say the plain language of the statute says 50%. It does not say percentage.
Let me ask you a
points.
preliminary question.
Yes.
The plaintiff is dead, correct? He
Yes.
passed
Yes.
away. So why is this a lost opportunity case? Why isn't it a traditional med mal? Was there more likely than not proximate causation?
Because the plaintiff's theory of the malpractice is that Dr. Al-Sawa failed to diagnose the metastatic cancer, and that not that he misdiagnosed or he missed the diagnosis entirely, but that he failed to diagnose the metastases. And because of that 2-year delay, that removed any opportunity she would have had to have a better result. So we're not contending she.
Doesn't the case law say that it's only a loss of opportunity case if the physical harm has not yet occurred?
Don't know that it's as clear as that. I mean, plaintiff's position is that, plaintiff's position is that, she had colorectal cancer years prior. She has successful resection surgery. We understand cancer is recurrent. She was being surveilled for cancer recurrence for many years. Obviously, we're not contending the defendant caused her cancer to return. What we are contending is that he did not timely diagnose cancer or the metastases of the cancer, and that led to her being in this less favorable category for a successful outcome. And that really, it gets to what I think the main issue here on appeal is the parties agree what the national cancer data statistics say for survivability. It's not great. It's 14 to 16%. It's averaging 15%. Where we diverge is basically whether or not you look at that statistic just at face value and in isolation, or if you have to look at it more tailored to the specific patient. And to that point, plaintiff proffered published medical literature and had their expert testify that Mrs. Benigni was actually more like this group of stage 4 metastatic patients who have the potential for a resection surgery. And if she had the potential for a resection surgery, those 14 to 16% statistics now become 24 to 58 with an average of 40%. Defendant's position is that, Mrs. Benigni actually was never a surgical candidate for resection, so that group of statistics never would have applied to her. And the reason plaintiff contends that she was in fact a surgical candidate is because a cancer surgeon told her she was. I mean, Dr. Rafoy told her, whom defendant referred Ms. Benigni for a surgical consult once we knew the cancer was back. He said, this procedure is technically feasible. I can perform this resection procedure. My concern is for her overall recovery based on her poor performance status. And that's really the issue I think we need to drill down on is, was she a candidate or was she not? Does she fit in this category or does she not? And defendant and trial counsel or trial court judge said, we don't think she fits here because she has other comorbidities. We don't think she would have actually been one of the people this article is talking about. And my answer to that is that Dr. Rafoy, at the time he made his surgical recommendation, was aware of all of those things. He knew what other ailments she had. He knew that the cancer had metastasized to more than one site. He knew the size of the tumor. He knew the location of the tumor. He knew all of those things and still opined, this is a surgery I can perform.
So counsel, is it your position that her likelihood of survival, better result, whatever, dropped from 40 to 15%? Is that?
Yes, if you're taking just the average of both of the competing statistics, there's a much wider range. If she was a surgical candidate, that's 24 to 58%. So there's multiple points along that spectrum that you could run the calculus and end up at a greater than 50% loss. But just taking the midpoints from all of the literature, we're saying she went from having a 40% opportunity as a surgical candidate to a 15% because she was not able to have that surgery because of her poor performance status. And plaintiff's argument is that poor performance status was a result of this cancer not being diagnosed in 2015 when our expert opined it should have been, and instead being diagnosed in 2017. And that poor performance and that decline could be attributable to the fact that the cancer was running rampant through her body with absolutely no treatment. It could be contributed to by other ailments or conditions she had. But the reality, and it's reviewed in the defendant's own deposition, is that her performance continued to decline in this 2-year period. So to say Mrs. Benigni had a poor performance status in 2015, surgery wasn't viable then, surgery wasn't viable in 2017, that's just not borne out. I mean, defendant Alsala himself testified that she continued to decline. And the idea that she wasn't actually a surgical candidate, I just don't think is in any way supported by the record, especially when both our expert and defendant's expert testified that you're performing this surveillance and you're sending patients for these CTs and these surgical consults with the view that there is a potential for something to be done here, that you would not continue to subject a patient who had no opportunity at all. So the fact that he continued to surveil her, he continued to do CEA testing for years, he continued to do annual CT scans, he sent her for a PET scan, he sent her for a surgical consult, all of that supports the fact that what the issue was her poor performance status at the time of diagnosis. Our position is if you had found this 2 years earlier, she's in a better position of overall health. She can tolerate a surgery. That puts her in a better category for survival. And, I think the quantity of the loss of opportunity is dictated by statute, and that's for a judge to decide what is this actual loss. But the quality of what that opportunity would have been, I really think is more for a jury to decide. And, defendant's position has always kind of been Mrs. Benigni was a lost cause. These are terrible cancer statistics. This is a really unfortunate reality. And that's true, but she isn't just this unilateral all-comer patient that's in this national cancer data. She very clearly fits into this range of someone who had the potential for resection surgery. And maybe a juror or jury would conclude, maybe she had this chance, but we don't think it would have changed anything. We don't think that's a meaningful opportunity. Maybe they will agree she was a lost cause. Maybe they'll accept defendant's argument, but maybe they won't. And the fact that a reasonable person could conclude otherwise, I think renders summary disposition inappropriate. And for that reason, plaintiff would ask that you reverse and remand us back to the trial court.
Thank you very much. You do have a few minutes for rebuttal.
Thank you.
Good morning, Your Honors. Joanne G. Swanson, appearing on behalf of Dr. Helsawa and Huron Medical. It's a little unsettling to be sitting here and having words put in my mouth. If it's all right with the court and plaintiff's counsel, I am going to make my own argument. And I'm going to tell you what our position is on these issues. And the first point I want to make is what you just heard is attorney argument. Their entire causation theory, proximate causation theory, is attorney argument. It is not supported by the facts. It is not supported by the evidence. And some of the things that you just heard were in fact contradicted by plaintiff's own expert. So the basis for the trial court's grant of summary disposition is that the theory was based on speculation. Whether the metastasis was confined to a single location and could have been detected in 2015, speculative. Whether it was treatable by resection in 2015, speculative. Whether if it had been resected, it would have increased her opportunity to survive, speculative. And in fact, there are no applicable is the key word here, statistical evidence to support plaintiff's proximate cause loss of opportunity burden. Whether her poor performance was a result of the delay in detecting the metastasis, that is plaintiff's theory. That is not supported by her expert. It's not supported by the medical records, and it's in fact belied by the records. So I will grant to you that this is not an easy case, but it isn't a close case. It's not easy because it's tempting to be drawn into the syllogism that you just heard, but it collapses in the details. It collapses in the science. It collapses in the testimony, in the written arguments and the law, in the medical records, as well as in the literature. Both experts in this case acknowledge that the survival statistics for metastatic colorectal cancer are the statistics provided by the National Cancer Institute SEER program, as well as the American Joint Commission on Cancer. And you heard what those statistics were in 2015. They were anywhere between 14 and 16%. It did not change 18 months later, and it certainly did not decrease by 50 percentage points. And we have not conceded, and we do not concede that we apply anything in this case other than the Fulton formulation. And the Fulton formulation is 50 percentage points. I know a lot of people don't like that.
It certainly doesn't jive with middle school arithmetic, but
yes, well,
that's what it said.
it jives with arithmetic, but perhaps, our justices have opined that it doesn't jive with the language of the statute. But plaintiff admitted in his brief that Fulton does apply. And in fact, the trial court explained in its opinion that the parties agree that Fulton is the controlling interpretation and is the law that applies to this case. So we know Fulton is a subtraction case. It subtracts the opportunity to survive before the malpractice. I'm sorry, with the malpractice from the opportunity to survive without.
But it's your position that even if she's right on Fulton, there's no evidence that it was
Absolutely.
50%.
That's correct. Even if she's right, they still don't. And I'll touch upon that in a minute. So plaintiff cannot survive. She cannot establish her case based upon the statistics. But let's start with a couple of things about the standard. At the hearing on the motion for summary disposition, in addition to this Fulton applies, the trial court asked plaintiff's attorney a couple of very direct questions. The first question that are in my notes anyway, there were probably others. The trial court asked plaintiff's attorney whether she agreed that the lost opportunity to survive had to be quantified. And the place that it is quantified is in the literature. And plaintiff's attorney agreed with that. And then the trial court asked again, but it still has to result in a statistical survivability consistent with the statute, right? And the plaintiff's attorney said yes. So let's start with what plaintiff says about Dr. Gordon, her expert. She already said today, he agrees with the SEER data and he agrees with the ACCN data. That's the 14 to 16% starting point of survivability in 2015. He agrees she was stage 4 colorectal cancer, had the 14%, agrees that agrees with the diagnosis, agrees that it's a difficult diagnosis to make, a difficult cancer to treat, and that metastasis is difficult to contain. It travels through the blood. It didn't jump over a few other organs. This is a blood-borne metastasis. Plaintiff's attorney then went on to say in her argument that Dr. Gordon says it does depend because you have different treatment options and it depends on what's going on with the patient. And she added, it probably should have been while Dr. Gordon doesn't offer maybe a specific exact number, he says all along, had it been caught earlier, she had greater opportunities for different modalities. These greater opportunities for different modalities is what plaintiff offers to meet her burden under the statute. It isn't enough. It doesn't quantify the loss of opportunity, and the absence of quantification is endemic throughout plaintiff's brief. On page 6 and on page 9, for example, plaintiff argues an earlier diagnosis would have placed Mrs. Benigni in a more favorable category for successful treatment outcome. On page 4, the literature shows earlier diagnosis would have allowed for curative treatment, including surgical resection, which would have placed Mrs. Benigni in a favorable category for successful treatment outcome. Goes on and on. Page 15, same thing, more favorable category. Page 25, more favorable category. That is not a quantification under the statute. It is not what plaintiff's attorney admitted was required under Fulton, and it is not what the statute requires. Plaintiff in her brief summarized this. If the liver metastasis was diagnosed in November 2015 rather than 2017, it is more likely Mrs. Benigni would have had an option for curative intent surgery as well as additional treatment modalities. These modalities would have provided an opportunity to achieve a better result, including survival. An opportunity. That is, in plaintiff's own words, it does not satisfy the statute. Beyond the fact that it doesn't quantify and it doesn't show an opportunity to have a better result that's greater than 50%. Better treatment modalities does not equate to survivability. If you look at the literature that was attached to Dr. Gordon's affidavit, you will see this. For example, in the CEA Watch randomized trial article, which was Exhibit 3B to Dr. Gordon's affidavit, there is an acknowledgement that treatment with curative intent is not the same as survival. And I say this because the article states the final proof of the value and strength of this new protocol will be if the effects of the intensified CEA-based follow-up strategy will result in higher disease-specific and overall survival with acceptable quality of life and cost effectiveness rates. That wasn't the conclusion of the article. That was, okay, the next step. Here are the treatment. Now we have to, the next thing is going to be to figure out, do these treatment modalities actually increase survival? Another article, Dr. Gordon, that's attached to his affidavit, Survival Outcomes. It's from the Oncologist 2016. The article states, although many prospective randomized controlled trials comparing intensive to standard follow-up failed to demonstrate any effect on survival benefit, a more recent meta-analysis has suggested contrary findings, suggesting that intensive follow-up confers a survival advantage. So you have two things that don't go very far in the law. One is a suggestion. The statute requires more than a suggestion. It also requires more than a survival advantage. It requires an opportunity to survive that's greater than 50%. There are more statements as well in these articles,
We
but
don't
I
need to go through them. We have some, you get your point about what Dr. Gordon testified and didn't testify.
okay, so what does plaintiff now rely upon? A plaintiff has admitted that you have to quantify the lost opportunity, and it has to be in the literature. Throughout the deposition of Dr. Gordon, he refused to quantify. He did what plaintiff's attorney said. He said, well, it depends. It depends. I'll have to look that up. I don't know. He would not give a quantification. Then in his affidavit, in response to summary disposition, suddenly he cites these statistics from this up-to-date article, which plaintiff cited for the proposition that resection offers the greatest likelihood of cure for patients with liver isolated CRC, and in surgical case series, 5-year survival rates after resection range from 25 to 40, I'm sorry, 24 to 58%, averaging 40%. Dr. Gordon cited these statistics, but he did not discuss the article. There is no expert testimony that shows how or why this article has anything to do with Mrs. Benigni. They don't describe the case studies. They don't describe the study subjects. And there is no explanation as to why she would even fit into the category of case studies that this article addressed. And in fact, the second sentence of the article would exclude Mrs. Benigni. It states that fully 2/3 of patients have extrahepatic spread beyond the liver, and thus are not candidates for liver resection. The article also says subgroups with advanced age, comorbid disease, and synchronous hepatic and colon resection have higher procedure-related mortalities and worse long-term outcomes. And then the article talks about a 5-year, a 5-year survival rate was only 25% in Medicare patients in one study. So we've got an article that then concludes, it is safe to say that a majority of patients with metastatic disease are not potentially curative surgical candidates because of tumor size, location, multifocality, and inadequate hepatic service. I am sorry to be quoting so much of this literature, but I don't want to put words in anyone's mouth. I want you to hear what the literature says, because the literature is key, and the literature does not support a loss of opportunity. So just to talk about this all-comer issue that Dr. Gordon refused, to acknowledge any statistic would apply necessarily to Mrs. Benigni from the SEER and the ACCJ, except perhaps the up-to-date ones, but he never explained why that applied. But the thing here about the all-comers is, and going back to Lanigan, the all-comer statistic actually confers a benefit on Mrs. Benigni because she is not the Lanigan healthy, athletic type of plaintiff that would be dragged down by a general statistic that includes people with comorbidities and other health problems. Mrs. Benigni is actually raised up by this because she is one of the ones that would be in the worst condition with her multiple longstanding comorbidities. So the all-comer issue is a red herring. And then a brief mention of this poor performance status. You heard basically the testimony of plaintiff's attorney that her performance status in 2017 was due to the undetected metastasis. I didn't see any testimony that reached that conclusion. I don't think, I read his deposition, I could have missed it. I don't think he said that her poor performance status was due to the undetected metastasis.
Not surprising that one's performance status would decrease when over 2 years of suffering from metastatic cancer. That doesn't sound like a shocking proposition.
Well, let me tell you, give you a little more information because this is in the testimony. This is in Dr. Alsawa's testimony. And that is that her physical examination were okay with respect to detecting her liver enzymes were not affected by this metastasis. So the markers, the markers that you would have in a normal physical examination did not show necessarily deterioration due to metastasis. She did have a continuing progress of her neurological issues, which includes a softening of the cerebral tissue. And she did have neuropathy, and she did continue to have all of the other comorbidities that had plagued her since well before the initial diagnosis of cancer. Plaintiff's attorney also said that she would have been a surgical candidate in 2015. Again, who knows? We don't know whether she would have or not. But plaintiff's theory is, well, if she was a surgical candidate in 2017, she would have been a surgical candidate in 2015. Her expert did not agree that she was a surgical candidate. He said, well, at the time in 2017, at the time it was picked up, you had a cancer situation that was not amenable to having surgery in the liver. And you already had a disease that it was already spread beyond the liver. So I would say that there's a lot of supposition there. There's a lot of speculation there and not a lot of evidence and not a lot of facts. The trial court did a lot of work on this. It took its time and it did its job. And we would respectfully request that you affirm the grant of summary disposition.
So let's try to keep it brief if we can. We've got a lot of quotations on both sides.
I certainly will. Defense counsel says she doesn't want to put words in anyone's mouth. I would just say that she seems to be taking words out of Dr. Gordon's mouth. So while she may not be putting them there, I think she's taking them from him, because it is not true that he said, I don't have any statistics for you. I don't really know what would have been a different treatment outcome. That's not what he said in his deposition. He acknowledged the national cancer statistic data. He said that applies to all comers. He said specific treatment modalities included surgical resection, which is exactly the issue here that we're arguing over. Was Mrs. Benigni a surgical candidate, but for her poor performance status or not? That's what we need to decide. If she was a surgical candidate, she's in this 24 to 58% range. If she wasn't, she's not. And, the explanation of why she fits as a surgical candidate is because a cancer surgeon said she was. He said, I can do this surgery. I know it's in the adrenals. I know it's in the liver. I can take both of those out. So to say, well, the reason she couldn't have it in 2017 is because it had spread, and maybe in 2015 it hadn't spread. So maybe she was a candidate in 2015, but not 17. None of that is what we're actually talking about here. This cancer surgeon, a contemporaneous cancer surgeon, not someone who plaintiff's attorneys hired in the course of litigation to look back at records and make a supposition or a speculative diagnosis, a contemporaneous cancer surgeon said, I can do this surgery. This surgery was not done because of her poor performance status. Mrs. Benigni's poor performance status was a result of the 2-year delay in treatment and diagnosis by defendant. And, that's really what this case turns on. And I feel a little bit like we're talking past each
Let me tell
other.
you, we have all read the material, and if need be, we'll read it again. So I mean, the argument about who said what is not all that impressive at this point because we have it in front of us.
Right.
We're interested if you have additional legal argument. I understand your rebuttal to her factual recitation. I think we all do.
The only other thing I would add then is on the Fulton points. If the court, I think what Fulton stands for is that you do not need an initial opportunity greater than 50%. The fact that they employ a calculation that makes absolutely no sense and is completely illogical and has it been acknowledged by a majority of the Supreme Court as being illogical, I do not think that's what the central holding of Fulton was. I do not think this court needs to apply an illogical formulation. To the extent this court feels that they must and are compelled to, I would just ask that that be pointed out. So potentially the Supreme Court takes the opportunity to recalculate how this should be done so that other plaintiffs don't end up in the same position. For everything else, I would just rest on my briefs.
Thank you both.
Thank you.
Very well argued. The last case for argument today is number 9, and it's Wilk v. State Bank, docket 357707.
Good afternoon, Your Honors. All of you, in person and virtual. My name is Sam Morgan. I represent the appellant in this case, Matthew Wilk. This is an appeal from a summary disposition motion granted under Section C8 of the summary disposition rule. I think that what I'd like to do today is focus first on the timeline of what occurred to make sure that the court is fully aware of what the factual basis alleged in the complaint.
I think we should reiterate that we are really very familiar with the facts in all of these cases. And so you're really best helping us by focusing on your legal issues and then as the facts intertwine. But we really are very, very well prepped on facts.
Okay, Your Honor. This is a classic example of a public policy wrongful discharge case that exists under the third prong that's recognized by the Michigan Supreme Court in the Solchegelsky versus Michigan Consolidated Gas case from 1982. The three types or prongs of wrongful discharge case that have been recognized under the public policy exception are: 1, where an explicit legislative statement prohibiting discharge, discipline, or other adverse treatment of employers or employees who act in accordance with statutory rights or duties, such as the Elliott Larson Civil Rights Act, which prohibits race discrimination. Secondly, a discharge where the termination is due to the refusal of the employee to violate the law in the course of performing their job, when they get fired because they refuse to perform, to commit a crime in the course of performing their job. And third, where the reason for the discharge is due to the employee's exercise of a right conferred by a well-established legislative enactment. And in this case, we're alleging, and we believe that the case exists under the third prong. The third prong being that Mr. Wilk, who was a loan officer, who was compensated based on a combination of a salary and an incentive compensation plan.
Got that. And then there was this memo from the senior vice president, whoever that is, regarding a decision that was made or not made. Obviously, that's in dispute. And then they changed their mind, apparently, perhaps related to your client's complaint. So can you tell me, I know I'm maybe jumping ahead, but where is the question of fact as to whether or not there was a violation of law as opposed to a potential violation?
Well, so this sort of like, this is the difference between the public policy claim, which is based on the assertion of the right under the Wage and Fringe Benefit Act to be paid in full and on time. That's a statutory right. This court in the Cockles case in 1985 declared that when someone demands to be paid their commissions, and it doesn't matter if the commissions are overdue and haven't been paid yet, it can be when they're about to, in advance of when they're due, but when the employer is saying, I'm not going to pay you that full commission. When the employee asserts the right to demand to be paid in full and on time, the Court of Appeals ruled in the Cockles case that that is the assertion of a right that is conferred upon the employee. Cockles versus, it's the 1985 case by the Michigan Court of Appeals, Cockles versus International Business Expositions. This differs then from the Whistleblower Act claim, which the Pace decision from the Michigan Supreme Court dealt with, and dealt specifically with the statutory language in the Whistleblower Act, which talks about a violation of law that has occurred. The Supreme Court, interpreting the text of the Whistleblower Act, says a violation of law means that it has to have occurred. The violation of law has to have occurred. Different from public policy, where an employee is asserting a right under the statute. In this case, the circuit court, in the oral argument, it's at page 20 of the May 17th hearing transcript, said that what I don't get is why, after he said what he said, when he asserted his right, if he got what he was entitled to receive in compensation, why would he have a claim for being fired in retaliation for asserting his rights under the statute? So this statute has a number of different rights that an employee has that the statute says an employee can't be fired from, or as a result. For example, section 13A of the statute, this is the Wages and Fringe Benefit Act. And this, just to explain how well established the Wages and Fringe Benefit Act is as a legislative enactment. It's been around since 1978 in its current state, so it's nearly a half century old. But it is a combination of three different statutes that existed going back to 1897. The main statute was a 1925 statute called the Wage and Lien Act. And that's the statute that made its way into the current Wages and Fringe Benefit Act provision that describes that an employer has to pay an employee the wages that they've earned in the previous month by the 15th day of the month. They can only go 15 days in arrears. So this legislative enactment has a history that's nearly a century old. And so I'm sorry, I forgot your question. Could you remind me what you asked?
Sure. Well, actually, my question then is, it sounds to me like you're saying we're not worried right now about the Whistleblower Protection Act. This is a separate statute under which public policy common law cause of action could arise.
Yes, it does. Actually, the finding of the court that the Whistleblower Act doesn't apply takes out the defense that there's a preemption by the Whistleblower Act. If the Whistleblower Act doesn't apply, the Whistleblower Act doesn't preempt the public policy wrongful discharge claim. It only preempts the claim if it applies. But in this case, the difference is that when an employee asserts the rights under the statute, now I remember where it was. For example, 13A says that gives an employee the right to be able to disclose their wages to other employees or third parties, such as people who are organizing unions. And it is prohibited, an employer is prohibited by the statute from disciplining, doing something adverse, including discharging an employee because they have disclosed their wage rate or their wages to third parties. And it's illegal for the employer to have a policy that prohibits disclosure of wage rates to third parties. That part of the statute specifically prohibits a certain type of discharge. And it was that statute, that section of the statute, which has caused a confusion that now exists as a result of the Rio case. We have in this statute, we have a provision, section 11, which is the general provision that allows an employee who believes their rights under the statute have been violated, such as I haven't been paid my wages, or the employer has taken deductions from my paycheck without my written and free and willing consent. Those are violations of the statute. They haven't paid me overtime. Those types of claims, those can be pursued under section 11. If the employer gets sore about the employee filing a complaint about such a violation and terminates the employee, section 13 of the statute, not 13A, but section 13.
I don't mean to interrupt you, but one question I had was, in this case, because of the wording of that letter, it seems to me that the commission that was due to be paid was not yet accrued. Like he was due to be paid at the end of the month. And then the letter that was sent said, if you don't pay us, then you'll be in violation of this. And then he was paid, correct?
The letter was addressing an email that said, we're cutting the percentage on the fee share from 10% to 5%.
Mhm.
And then the letter that was sent by counsel for Mr. Wilk to the employer said that if you do an after the fact retroactive, this is like cutting someone's rate of pay after they've earned it. If you do a retroactive reduction in pay on this incentive comp, because the quarter has ended, the incentive comp has been earned. This was a $65,000 cut, a potential cut in the incentive payment. If you do that, and they had already announced that they're going to pay it at the end of the month, end of July. If you do that, that's a violation. That'll be a violation of the statute, because under the statute, I have the right to be paid on time and in full. If you do that, I'm going to file a complaint, a section 11 complaint with the Department of Labor Wage and Hour Division. 3 weeks later, they backed down.
Is there anything in the Wage Benefit Act that says if you're fired for bringing a complaint under this, or for asserting that you're going to bring a complaint under this, they can't retaliate, that there's a non-retaliation provision?
Yes, there is. Section 13 provides a non-retaliation provision. If you file a complaint, the third subsection in that says, if you exercise rights under this statute for an employee or others, it's a wrongful termination. What happened is that in the Rio case in 1995, Rio versus Lane Bryant, the Court of Appeals decided that in interpreting that section, that the cause of action that can be pursued for exercising rights on behalf of an employee was only exercising rights on behalf of someone other than yourself. And the court was really trying to relieve that claimant, that plaintiff in that case, from the adverse effect of a 30-day statute of limitations that exists under that anti-retaliation claim. That particular plaintiff was complaining that they were discharged in retaliation for disclosing their wages, which is a Section 13A claim. And the Court of Appeals said that they ruled that the 12-month period of limitations that exists under Section 11 should be the one that applied, and that the 30-day statute of limitations under Section 13 doesn't apply because the language, as they interpreted it, means that the employee who asserts rights under the Act is protected from discharge or discrimination only if they're asserting rights on behalf of someone else, someone other than themselves. And that is what in 2018, another panel of this court ruled, or actually observed, that they thought that Rio was decided incorrectly, called for a conflict panel to be convened. One was not convened. There was an application for leave to appeal to the Supreme Court. And the Supreme Court decided that they weren't going to review the issue. But the panel in the Ramos case observed that this issue has already been decided by the Cockles case in 1985, where the court ruled that when someone asserts their right to be paid their compensation in full and on time, they are asserting rights that are conferred upon them by this statute. And the only reason the Cockles court didn't get to the next question of whether or not that is the type of exercise of statutory rights that falls within the public policy, the third prong of the public policy exception, is because the plaintiff and the defendant in the Cockles case had a stipulation that if the court found that the rights were being exercised pursuant to rights conferred by the statute, then the plaintiff would be bound to follow their administrative remedies under Section 13.
But didn't Cockles involve commissions that were already past due?
No, the court made clear that the plaintiff's complaint, made clear in two different parts of the decision. The plaintiff's complaint did not specify whether they're past due or not. And so the result of that case is that the court ruled that just by asserting a demand to be paid your compensation in full and on time is the assertion of the right under Section 2, or if it's a fringe benefit, like a bonus plan, like an incentive compensation plan, Section 3, that's the assertion of rights conferred by the statute. It seems that you've got this sort of.
We do. If you want to just, cut it here, and you got plenty of time for rebuttal.
I'd like to just summarize is that it bears. I've been doing employment law for 32 years. This trilogy of cases, Cockles, Rios, and Ramos, have created an impossible situation for claimants who no one wants to wait until payday comes to find out if they're in fact going to do what they told you they were going to do to you. You say something to compel the employer to do the right thing, don't violate the law, pay me in full. And if you succeed, what the trial court did in this case says, too bad, now you're not protected.
But if you fail, you are.
If you fail and they don't pay you in full, then you're protected and you have to pursue your claim under Section 11 of the Wages and Fringe Benefit Act. Well, what we have here is that the Court of Appeal says that there is no remedy under the remedial scheme that's provided under Section 13 of the statute, because you're asserting rights on your own behalf, not on behalf of others. And so then if you're asserting rights that belong to you as an employee conferred by this statute, and there is no statutory remedial process available to you that's created by this statute, you're left with either your SOL, you don't have a claim, which if you look at the different sections of the Wages and Fringe Benefit Act, it's full of intent by the legislature to protect employees and to protect them from retaliation when they stand up for their wage rights at work. This is a situation where, as a result of the Rios case, which was, I think, an unintended mistake or error by the Court of Appeals to relieve a claimant from the short statute of limitations that had been ruled against him. As a result, has created the situation where the Ramos case says Rios got it wrong and someone has to fix this. And what we're asking this court to do is to fix this, because the trial court made an error. If the trial court's position is that, okay, yeah, you were right. Thanks for asserting your rights under this statute. Now you got paid, but they can come after you. That's the chilling effect on any employee to stand up for their rights regarding their wages at work before payday comes. Because payday is important. Okay, if Mr. Wilk worked last month in May, and in the last 15 days of the month, he was working at the rate of $30 an hour. And we're here today, I'm the employer. It's June 7th. And I say, you know what, Matt? I'm only going to pay you $12 an hour for the time that you worked in May. And he says, wait a minute, you can't change it after the fact. If you do, I'm going to file a complaint
This we know.
with the wage.
You don't have to give us the
Okay.
facts again.
All right, so what this decision in this case has done is that it says that the person who says you can't cut my hourly wage into a fraction after the fact that I've earned them has no protection for
You have to
standing up
pay
for
him
his
and then you
rights.
can fire him.
Pardon?
You got to pay him and then you can fire him. That's what you're saying. I mean,
No, you have to pay them and you can't fire
no, I'm
him.
saying, but that's the problem.
That's the problem. They leave the employee who exercised their rights bare, unprotected, when there's the third prong of the public policy wrongful discharge theory available that creates a cause of action for someone who is terminated because they have exercised a statutory right that belongs to them as an employee. Thank you.
Thank you very much. Counsel, I have two names here. I'm not sure which is you.
Good afternoon, Your Honor, and may it please the court. My name is RJ Cronkite. I'm counsel for defendants appellees, State Bank and Ronald Justice. Unclear based on oral argument that I just heard whether there's no more argument in terms of the Whistleblower Protection Act. But I do want to address that in addition to the public policy argument that Mr. Morgan focused his oral argument on today. So this court should affirm for two reasons, two principal reasons. First, looking at the Whistleblower Protection Act claim that was dismissed under C8 by Judge Hegarty below, there's no violation, as a matter of law, there's no violation or a suspected violation of law under the Whistleblower Protection Act based on a claim that the employer intended to violate the law. And that's the Pace decision, which I know Your Honor is intimately familiar with. You authored the Pace decision.
I authored the Pace
You did.
decision. Well, what do you know?
You authored the Pace decision, and it was a clarification by the Michigan Supreme Court in terms of what is a permissible claim under the Whistleblower Protection Act. Can you, in effect, say, I have noticed that there is an intent, a plan, active plan to violate a law and I've made a report under the Whistleblower Protection Act, none of that's in dispute in terms of the facts and pace. Is that cognizable as a violation or suspected violation under the Whistleblower Act? This court said yes.
So I wrote the decision that was reversed, but
That is correct, Your Honor.
okay, that's what I was confused.
That is correct, Your
Okay.
Honor. And it's interesting too, because what the Pace Court above said was a few things. Well, the first principle is that a violation or a suspected violation of law is an existing violation of law. Quote, it's occurred, or quote, it's ongoing. So the violation has had to have occurred. Number two, what isn't a violation or suspected violation of law under the Whistleblower Protection Act? An intent to violate a law in the future. That's the Pace Court's words. That is not a cognizable claim under the Whistleblower Protection Act. It's not protected activity. And further, the Pace decision clarified that a good faith and reasonable belief that a violation of the law is being actively planned. So they're planning, my employer is planning to violate, for instance, the WFDA. And they've told me that, that's the claim here in this case. They intend to violate the WFDA by in the future not paying me what I'm owed. What the Pace Court said is that's not cognizable under the Whistleblower Protection Act. And I think that's why the oral argument today, we're not really hearing an argument that should be reversed. Judge Hegarty got that right. He's very thoughtful.
I'm very interested. I get your points on the Whistleblower Protection Act. Can we focus the argument on the public policy?
Absolutely, Your Honor. Absolutely. And the principal reason that the court should affirm the dismissal of the public policy claim is it's really derivative of the claim that the Whistleblower Protection Act was violated. If you look at the second amended complaint, 3 bites of the apple here, what you see pled.
But isn't that the whole point of a public policy claim, is that you don't have one under the statute, so you have one through public policy?
It's an alternative count.
Yeah.
That's correct, Your Honor. It's an alternative count. You potentially have a claim. That doesn't necessarily mean just because I strike out on one, I automatically home run or get to third base on public policy claim. But here, under these facts, and as taking the complaint as pled, the second amended complaint as pled, the public policy argument is strictly based on a violation of the WFPA. And that's the problem here. That was what Judge Hegarty was struggling with, as he said, there's no violation of law. Yet we can take for granted that the WFPA, and that is a clearly enacted legislation protection. I mean, that's a public policy for purposes of public policy. There's no doubt about that. The problem is when you look at what is the violation of the public policy. And then what ended up happening is you go, based on the complaint, you go back to the WFPA violation that is not a violation under PACE. And that's the problem is Mr. Morgan and Mr. Wilk are.
Did PACE deal with that?
It did not.
With that statute? Didn't it deal, isn't this the one about the refrigerator somebody wanted?
That's correct. It was a violation by misuse of public funding, basically.
You don't think there's any difference in public policy arising under a different statute, or I'm a little confused there, I'm sorry.
Well, here is the issue is that under the Whistleblower Protection Act, there is no language in the Whistleblower Protection Act, just as there is no language in the WFPA that says a intent to commit a violation is cognizable. And so,
well, if that was the case, they wouldn't need a public policy theory. They'd have a statute, right? I mean, they would just say it was retaliation, and that's barred by statute.
Well, in an instance of a statutory violation, perhaps, but there are other public policies that are not statutorily based where it could be applicable. But what ends up happening here is when the public policy that is allegedly violated is that there was an intent not to pay the commissions. But there is no public policy that prohibits.
I thought the public, maybe I'm mistaken, I thought the public policy was firing someone for making a complaint that their wages were about to be wrongfully cut.
And I agree with you. But that's the problem, is when you look at the WFBA, where is the right conferred that an employee may demand payment of undue wages or commissions?
After they get an email from a vice president that says we ain't paying you. I'm confused. I honestly, but that's my problem.
Well, you had asked, Your Honor, earlier, appellant, what is the retaliatory, is there a retaliatory section to the W? And there is.
There is, okay.
There is.
See, I need to do this.
But here is what it pertains to. Is there are enumerated instances of retaliate that prohibit the retaliatory discharge when you have to make a complaint. There was no complaint filed in this matter.
I understand.
And the reason, and this was admitted to at oral argument below, the reason no complaint was filed is because there was no violation of the WFBA. It was honored. And the other instance is where you cannot retaliate is where the employee exercises a right under the WFBA. But Mr. Morgan, they do not identify what the right was. There's no right under the WFBA to demand payment of undue fees. What does the WFBA mandate? You have to pay your employees what they're owed in wages, commissions, fringe benefits when they're owed. And Judge Patel, I believe, asked earlier, appellant, well, isn't it true that in fact, Mr. Wilk was in fact paid what he was owed when it was due? And just looking at the complaint, it wasn't directly answered. Looking at the complaint, it's even pled that it was paid when it was due. I mean, Mr. Wilk said that there was, and this is paragraphs 31, 32, and 38 of the Second Amendment complaint. 31 says that State Bank stated that its goal was to pay the reduced fee share payments to employees like Wilk in the last pay period of July. This letter was dated July 7th. Paragraph 32 says, on or about July 7th, 2020, through a letter from his counsel, Wilk notified the State Bank and Mr. Justice that he was aware that the State Bank intended to change the fee share compensation on PPP loans through the SBA after the fact from 10 to 5%. And paragraph 38
Counsel,
says,
I understand. There's no doubt that the cut did not occur.
exactly, the cut did not occur. There's no right that was violated of Mr. Wilk under the WFBA. And the problem with the argument in the reliance on cockles, and this was asked too of appellant, isn't it true that in cockles, the commissions were in fact unpaid? And that is true, they were unpaid. And if you look at the reply brief of appellant on pages 8 and 9, he actually has a very, I believe, very helpful citation to cockles, talking about the facts and the finding, the holding of cockles. Wilk's position is that it's irrelevant whether the wages, commissions owing under the WFBA were yet due and unpaid. Irrelevant, but that's not what this excerpt says. It says the allegations in plaintiff's complaint do not specifically claim that plaintiff was not paid in accordance with the exact schedules set forth in MCL 408.472. Rather, plaintiff alleged that she demanded payment of approximately $2,000 in commissions owed plaintiff, and this is the key part, and unpaid. Now, what the Cockles court was explaining here is like, look, we're not going to jam the plaintiff up in Cockles on a technicality because she did not cite chapter and verse that you did not honor, employer, the requirement to pay me according to the schedules set forth in WFBA. The point is, this plaintiff was owed money. It was unpaid. She demanded payment and you didn't. And then she claims you fired her after she demanded payment, cognizable under Cockles, not the facts here, not what was pled in the complaint. It's different to say, State Bank taking the facts as they are pled as we must for purposes of CA, that State Bank communicated, we intend to cut your commissions at the last pay period in July. July 7th comes around. Mr. Morgan, on behalf of Mr. Wilk, says you cannot do that or you're violating the WFPA. And then State Bank never follows through and actually, as set forth in paragraph 38 of the Second Amendment complaint, pays everything owing, never violated the act. What we're left with for public policy, what was the right that was exercised and violated by Mr. Wilk? It does not exist. And I would say that if there's what I heard at the really close of the argument was really a request to amend the WFPA, to say, well, we have a problem where the WFPA doesn't permit this. We've got this issue where, well, maybe there should be a section in the WFPA that says if an employer announces an intent to violate and an employee brings it to the employer's attention, you can't do that. Maybe that should be enumerated as in protected activity, but it's not. But to use the public policy as a way around having the WFPA amended, it is not appropriate here because we're still left with looking at the legislative enactment, the public policy that is being relied on for the public policy argument, which is the WFPA. So when you look at the WFPA, nowhere do you find this right that Mr. Wilk is arguing was violated. There is no public policy.
I think we got it.
And I would also note that if that were the law, every time, I mean, imagine a world where every paycheck that comes due, an employee prospectively demands payment and says, look, you haven't violated the law yet, but you better pay me my next paycheck. If you don't pay me my next paycheck, you're gonna have a problem, which is true under the WFPA, but it gets paid. But then the employer gets terminated, the employee gets terminated and says, look, you violated public policy. I exercised my rights under the WFPA public policy to be paid. I was terminated after that. It's temporarily close in time, and therefore you violated public policy. It would just permit every employee just to demand something that they're not even entitled to prospectively and set up an infinite amount of claims under public policy theory. So I think Judge Haggerty gave this a lot of thought. He gave Mr. Morgan 2 opportunities to amend. At the end of the day, he doesn't have a cognizable claim. And so we respectfully request that the court affirm Judge Haggerty's decision.
Okay, so now, Mr. Morgan, you have a few minutes rebuttal. Please try to be brief. It's been a long day.
Thank you, Your Honor. First off, we're not abandoning the appeal of the whistleblower act. Dismissal, recognizing the hurdle that we have on that claim. We've decided to focus on the public policy wrongful discharge claim. Mr. Cronkite is very slick in trying to finesse this. The wages, the fee share compensation that Mr. Wilk earned was earned as the second quarter closed on June 30th. They just had to calculate how much it was, but he was supposed to get 10% fee share on all of the fees that were collected by the bank on SBA loans that he originated, and that closed in the second quarter that ended on June 30th. To that extent, the fee share compensation was earned. It was due to him. It was owed to him. He had a written compensation plan, incentive compensation plan that says, this is what you will get.
Counsel, we understand.
You get it at the end of the month.
Your position is that if you are retaliated against for bringing to the attention of your employer that they're about to improperly violate the act, and then they pay you, but then they fire you, that that's a violation of public policy.
Right, that is, and what's different from what Mr. Cronkite cautions this court about is that in this case, we have a written email that says, we're doing this. We're cutting it in half. It's a $65,000 cut to Mr. Wilk. And then we have a letter from Mr. Cronkite's partner backing off from that decision and just saying, well, we were thinking about doing it. We were contemplating it, but we're not going to do it. And then 2 days later, they fire him. Thank you.
Thank you both very much. An interesting issue. That matter is submitted, and our last case for today will be submitted on briefs. That is number 10, In re Fraser Goodwin Miners, docket 357856. Pardon me, I apologize. It's not the last one, or is it? Is Ms. Jones here? No, did Ms. Jones check in? All right. Well, item number 10 is submitted on briefs. And we are adjourned until tomorrow. Thank you very much. Judges, do we want to then wait till tomorrow? Is that what we're going to do?
That's what we discussed.
Right, that's fine by me. I mean, it's been a long day.
It's been a very long day. If it were earlier, I might be more amenable, but at this point, yeah.
Okay, then we will.
You know, you had never mind, I'll talk to you later.
Okay, very good.
Okay, thanks. Thank you, Doug. I appreciate your handling. Thank you.
Bye-bye.